Good morning, everyone. Welcome to the Joint Standing Committee on the Judiciary. We have a couple of work sessions this morning, and I believe that we are going to take them in order, the order listed on the notice, which is 2163 and then 2121. And as always, we are going to begin with committee member introductions. And let's see, Representative Babin, would you like to begin?
Good morning. I am Mark Babin. I represent House District 3, Northeast Aroostook County.
Good morning. My name is Ellie Sato. I represent House District 109 in the beautiful town of Gorham.
Hi, I'm Adam Lee. I represent House District 89, which is downtown and New Auburn.
Good morning. I'm Jennifer Poirier. I represent House District 70, which is Skowhegan.
I'm Amy Kuhn. I represent House District 111 in the town of Falmouth, and I serve as the House Chair of the committee. Welcome.
Good morning, I'm David Sinclair, here for the people of House District 50, the city of Bath.
Good morning, everyone. I'm Rachel Henderson. I represent the people of House District 78, which are the beautiful towns of Bethel, Byron, Milton, Hanover, Roxbury, and my hometown of Rumford.
Good morning, I'm Danielle Halloran, and I represent District 20, the industrial city of Brewer.
My name is Ann Carney. It's nice to see you all. I represent Senate District 29, which includes South Portland, Cape Elizabeth, and some of Scarborough, and I serve as the Senate Chair of the committee. And so let's open up the work session on our first bill. This is LD 2163, an act to improve the response to complaints by victims of crime and enhance victims' rights. And Janet, can you orient us to where we are on this one, please?
Certainly. So we've had a couple of work sessions on this bill at which we had different proposed amendments to the bill from the bill sponsor. And last time you took a caucus break and decided you wanted to consider the bill more before moving on. And in the meantime, the sponsor has prepared an additional proposed amendment that's being distributed now. And I'm happy to walk you through it and tell you what's different from the original bill and what's the same, if that would work for you.
That would be terrific, but let's give Senator Hagan a moment to introduce himself. Thank you, Janet.
Thank you very much, Madam Chair. I'm Dave Hagan, Senate District 10, 12 towns surrounding Bangor, not Bangor. Get after it.
Okay, so as originally drafted, this bill did a couple of things related to the rights of crime victims. It would have directed the creation of a centralized complaint process within the Office of the Attorney General for instances when a crime victim has a right in statute, but it's maybe not effectuated. And the design of that system was to have a way for the Attorney General's office to make recommendations to local prosecutors, who are usually the people who effectuate these rights, to say, like, let's maybe improve our processes to make sure the rights are followed. The other thing the original bill did was it gave a right for crime victims to have notice of certain other aspects of the criminal proceedings, and also to be able to appear whenever they have a right to appear through an attorney or through a victim witness advocate if they didn't want to personally speak to the court. As amended now in the version before you, which is on this lovely goldenrod sheet of paper, the title of the bill is changed to match what the contents now would be if you move forward with this amendment. So it would be an act to enhance victims' rights. The amendment would strike sections 1 and 2 of the bill. Those were the provisions that created that centralized complaint process within the Office of the Attorney General and might have required additional staff. So it gets rid of that process. If you remember from last time, we talked about maybe needing a public records exception review. That was related to confidentiality of those records. So if you go with this amendment, we don't need to do a full review on this bill. It retains sections 3 to 6 of the bill. So 3 and 4, which you can see, are just moving an and in a list of, a list that's this, semicolon, this, and the other. You just always need to move the and when you add new paragraphs. So section 5 was the provision of the bill that would have required the prosecutor to make a good faith effort to provide notice to the victim of any request or subpoena to request certain of the victim's records. And as amended, this would be clarified to say that it's only requests for the victim's records that are part of a criminal proceeding. And that it would add language that was originally in one part of the bill, but not this part of the bill, which describes the type of records that we're talking about, which are medical or mental health counseling records, treatment records, educational records, or cell phone records. So that's section 5, and that's the prosecutor being required to provide notice. And then section 6 would be preserved, and this is the prosecutor making a good faith effort to notify the victim of any outcome of an appeal involving the case for which the victim was the victim of the crime. Section 7 was a provision of the bill that cross-referenced the victim complaint process, so that doesn't need to be included if you move forward with this amendment. So the amendment would strike out section 7, and sections 8 and 9 of the bill would be retained. Section 8 is the other provision about the subpoena for victims' records. And this has language in it clarifying that the victim has a right to timely notice pursuant to the other section of the bill, which clarifies it's the prosecutor who provides notice. It's not that the court independently provides notice. And be given an opportunity to be heard at those criminal proceedings when a subpoena has been requested for the victim's records. And then section 9 of the bill is the provision of the bill that says that if the victim retains an attorney, so this isn't a right to PDS attorney, but if the victim retains an attorney, they can be heard at any court proceeding where they have a right to be heard through the attorney instead of personally speaking. And then also they could choose to be heard through a victim advocate. And then the language in the middle of this paragraph was added at the request of CLAC. It was before you last time, but just to remind you, there are provisions of the main rules of professional conduct that limit the way that an attorney can interact with a party who is also represented by an attorney in a matter. So the idea of this section of the bill was to say you can choose to appear through an attorney and that shouldn't affect your rights. And the only thing that the new language is saying, except they might have to talk to you through your attorney under the rules of professional conduct, but it still shouldn't affect otherwise how you're treated by the prosecutor. And then the summary just summarizes how the amendment changes the bill.
Thank you. Let's start with committee questions for Janet. Are there questions for Janet, committee members? Representative Henderson.
Thank you, Madam Chair. I think I missed this piece in the first work session. Does it specify what type of victim? Is it a sexual assault or domestic violence or just any victim of a crime?
Sure. So this is put into pre-existing law. So it was a buff handout at the public hearing. Hopefully you have it, but I can read you the definition. So the definition of victim, which is in Title 17A, Chapter 75, which is where the provisions of the bill that remain with this amendment, where they would be placed. A victim means a person who's the victim of a crime or the immediate family victim of a crime if the underlying crime is one of domestic violence or sexual assault, or one in which the family suffered serious physical trauma or serious financial loss. Or it could be the immediate family if due to the age, physical death, age, physical or mental disease, disorder, or defect, the victim is unable to participate. And then it defines who is immediate family. So those are the victims that already have the list of rights that are in 2102 currently to have notice of all of these types of proceedings. And this just adds some more notice provisions and then the right to be heard about the subpoena.
Do you have a follow-up question, Representative? Or are you all set? Okay, thank you. Committee members, other questions? Representative Lee?
I don't know why I'm noticing this now, but the last sentence in section 9, the way it's worded, I'm having some hesitation because it almost appears as if the victim doesn't have to provide consent to the victim witness advocate or coordinator to speak on their behalf. Is there something in the cited sections that would?
I can
notice?
adjust that language to make it mirror more the first sentence, which is the victim's choice.
Yeah, thank you.
Thank you. Additional questions? I have one question for you, Janet, and if it's not for you, then let me know and I will ask the bill sponsor who's here with us. I noticed in section 5, the list of records that might be subpoenaed includes cellular telephone records. And does that refer to records of how you've used your cell phone, or is it a record that might contain your cell phone number?
I think it would potentially be all of the above because this isn't including but not limited to lists, but it may be helpful to ask the sponsor what she intended to cover.
Okay. Could we hear from this bill sponsor, please? Welcome, Representative.
Thank you, Madam Chair. Representative Lori Gramlich, representing the lovely seaside community of Old Orchard Beach, and I'm an Assistant House Majority Leader and the sponsor of this bill, and did some work on this amendment. And can you repeat your question, please?
I would love to, and I'm going to expand it a little bit because I'll tell you my train of thought. So I was reading through section 5, and when I got to the cellular telephone records, my question was, are we calling that out in order to protect a cell phone number that might be the victim's private number that that is kept confidential from the person who committed the crime? And then I was thinking, well, maybe it's not just the number, maybe it's a record of cellular phone use. And then I started to wonder, well, how about records that have things like personal home addresses, work addresses, that sort of thing. And so I'm just wondering how extensive you think the descriptor needs to be in paragraph H. If you don't think it needs to be extended or modified in any way, that's fine. I'm just would like you to think about it in that broader way.
Yeah, no, I appreciate the question, Senator. And this would, in terms of the cell phones, it would be the latter of what you had described relative to not only the number and the records, but what the content is. And then your point relative to other information that is personalized to identify the victim, such as home address and what have you. Certainly if the committee sees fit, can include that information as well.
Do you know whether that information is already protected under some other
I do not.
applicable provision of law? Okay. Is there anyone with us in the committee room who might have an answer to that question? I see that Senator Hagan has a question for the bill sponsor, so we'll go forward with that and then come back to this issue.
Okay,
Go
so
ahead, Senator Hagan.
just content. Can you explain what you mean by content of the?
I'm sorry, Senator, I can't hear you.
Sorry. I know, I struggle. Deer
Same,
hunter.
and we're getting
I have
older,
no-
right?
I'm older, yeah. Had to have the eye test for my driver's license today. Anyway, so you mentioned content of the cellular telephone record. So I'm just curious, like phone calls that we made are revealed or researches or because they're a computer.
This
What
would be
does content mean?
Well, it would be specific to the victim, first of all, and it would be any contact that would identify that victim.
Representative O'Halloran?
Ah.
Oh, Janet?
So if you look at, hopefully you still have the handouts from current law, Title 17A, Chapter 75, where we found the definition of victim. Thankfully, I copied lots of pages because on page 5, section 2108, it talks about the confidentiality of records that pertain to a victim's current address or location.
Thank you, Janet, for answering that question.
And it even goes into, if you keep reading, like discovery and how that is handled. So the bill is more about specific requests either by the prosecutor or the defense for like groups of other records, because these records are already sort of addressed.
Thank you.
I'm looking to the people behind me to make sure I didn't split up. Okay.
Thank you. So I have another question for you, Representative Gramlich. So are you is cellular phone records, I know this isn't including but not limited to, but are you really intending to refer to any digital information that would be on a device used by the victim of the crime? So whether it was the content of your phone that was subpoenaed or the content of your Gmail account, anything
Or
like
your
that.
iPad or whatever the case may be, right?
Okay.
Yeah, I think I would rather be more inclusive relative to that data than exclusive and narrowly defined to cellular phone, because some people may not even use a cell phone or have a cell phone.
Okay. Janet, I know that you've worked with us on a lot of data privacy. Do you think that you could suggest in lieu of cellular telephone records, some category of documents that would encompass the electronic communications records?
Yes, I would look back at the statutes if you want to vote in favor of that and bring you preliminary language at a preliminary language review, but I would expand it to records related to digital devices and just see how that is written in other statutes, so we make sure we're consistent. Because I
Thank
know
you.
we have statutes about, the content of electronic communication. They're already in law, so we can find how it's written.
Okay, and so we would just match that. Thank you. Other questions, committee members? Representative Sinclair.
Thank you, Madam Chair. Good morning.
Good morning.
I don't know if you remember, I suspect you do, from some of the earlier work the committee's done on this bill, some members' concerns with the breadth of the about or concerning language. And I'm wondering if you gave any thought to that in terms of trying to narrow it a bit.
What section in the amendment are you referring to, Representative?
I think that it appears more than once, which is why I tried not to just direct us to one paragraph, but for starters, in section 5, paragraph H, the about or concerning the victim. One of the issues, just as a quick example, would be if a defense attorney were to subpoena an officer's records from that particular date. The about or concerning the victim language is pretty expansive and would seem to create for the victim a right to be heard at a hearing on a subpoena to be issued to an officer for their communications on that date. Is that your intent, or is that just an artifact of the language you put forward?
That would be the latter, Representative. And I know since you all last met, there had been a fair amount of work that occurred with advocates and with folks from the prosecutor's team and public defenders, so that we could really try to hammer this out in a way that met what we thought some of the concerns of the committee were. And those folks are here in the room that can speak more pointedly to that as well.
Did you have a follow-up, Representative? Were you thinking, pondering?
I have continued concern that the language hasn't changed and therefore has the breadth it had the last time the same bill was before us.
I will say it has changed slightly, but perhaps not sufficiently. So last time this point, I believe, was brought up by Representative Lee, and in section 8 of the bill, there was this including but not limited to list. That list was not included in section 5. So that's now been included in section 5. So as you know, ordinarily a court would look at that, say, what are similar types of records? A law enforcement record isn't a similar type of record, but there's no need to rely on that canon of construction. If you want to specifically say not a law enforcement record, you should say it. I think that's clearer.
Thank you for raising the issue, Representative, and thank you, Janet, for that information. Representative Lee?
I'm maybe testing my own memory here, but I thought the way that, or one of the ways we talked about resolving that issue was making it, so including the list, but saying it's the victim's record. And would that be inconsistent with your intent or consistent with your intent?
Consistent.
Okay, thank you.
I think that's hard to say because often they're third-party records. So I think it might be better to say something like not any records in the possession of the state or that are subject to Brady or anything like that. Like some other way of describing it, because it's not the victim's own records. They're getting that from the telephone company or the doctor.
Representative Lee?
I think, yeah, and I don't have the words right now, and I trust you to find the words. I think you know what we're trying to do, though, is to narrow it not to just be any record that concerns them, because as Representative Sinclair says, any record that concerns them is any record in the case, because it's being subpoenaed in a case in which they're the victim. So
You all set, Representative? Representative Henderson?
I'm hearing what both of my colleagues here are saying, and I'm kind of right there. I have another thing I think I'd like to touch on in a second, but would it be helpful to say something to the lines of a record initiated by the victim? I mean, maybe not generated by the victim because it's the healthcare provider that's generating it, but if it's generated by the initiation, right? If it's text message between two people, or if it's a healthcare record, or if it's a psychological evaluation, to be something that would have been initiated by the victim.
I think
Janet?
that might work, but I don't know if we're thinking of all the possible records. So I think it might be a better approach to think about what records are we not covering? And we're not covering records in the possession of prosecution or law enforcement. Like if there are clear records you don't want to cover, I think we should be very clear about that. Does that make sense?
It does. My brain works the opposite way. So to define what we are looking for, rather than trying to think of all the ways, all the things we're not, try to encompass all the different things that we're not trying to encompass.
I agree ordinarily, but I think in this case, we're trying to not limit the records we're covering, or at least that's my understanding of the bill. But we are trying to narrowly carve out something that is subject to different processes, which is there's discovery, there's other obligations of the state to be forthright to the defense about what information it has. And that is, if I'm understanding the concern correctly, a narrower category than the potential large category. Ordinarily, I agree with you, but I think we're just in a reverse situation here.
Any other thoughts or questions, committee members? Representative Lee?
could maybe pull up some people to get their input on this, like Andrew Mancuso, I think would be helpful.
So anything else for the bill sponsor or Janet at this point? They're not going anywhere. I'm assuming. Okay, great. Could we hear from Andrea Mancuso, at the request of Representative Lee? Thank you, Representative Gramlich.
Good morning, Andrea Mancuso, Policy Director with the Maine Coalition to End Domestic Violence. So I think my notes and Janet's notes around this from the last work session were, I think, that we were looking to mirror the language as between the two sections to address the problem. I think that's how we landed in the amendment language. But hearing the concern, I'm wondering if it might make sense to just cross-reference subpoenas issued through the, or record requests through the Rule 17A process that's happening, because that's really where this is coming up. And that rule is privileged or protected documentary evidence, right? So if you're seeking the production of documentary evidence that may be protected from disclosure by a privileged confidentiality protection or privacy protection under federal law, Maine law, or the Maine rules of evidence, it invokes this process, and that's fairly exclusively what we're talking about here.
And you have that rule, it was the white handout attached to the bill analysis, and I think you're referring to Rule 17A, subsection F. Yes.
Let's just give committee members a moment to find that. So it's the white page in the bill analysis. 17F. Okay, Representative Lee, does that seem to address it? And Representative Sinclair, I'm going to ask you the same question. And then I know Representative Henderson, you already also weighed in, so I'll ask you, all three of you, if that, you think that that meets the concerns, and other committee members are welcome to share their thoughts as well. So it's, if people are looking for it, it's the blue bill analysis. There's a white sheet after the blue bill analysis, and it's the third page of that white sheet. Second page, excuse me. Representative Lee.
I like that because it tethers it to something that already exists in law. And I'm also recalling someone testified, you don't need this because of Rule 17A. Which,
That was clap.
but we know from practice that's not accurate. And so actually referencing 17A upholds that consistency. So I think that's a great suggestion.
Great. Representative Sinclair? Do you have an opinion you'd like to express?
I was looking at another document at the point where Attorney Mancuso referenced 17A. I applaud generally the reference to 17A, but I would need to know where it's being proposed that would be stuck in.
So it's my understanding that the idea would be, instead of talking about just a subpoena issued for any record about or concerning a victim, it would be a subpoena covered by, or I'd think of a better phrase, Rule 17A, subsection F of the main rules of Unified Criminal Procedure. For
When
a
it's-
record about or concerning a victim. So it's victim records that are within the scope of Rule 17A, subsection F. And I would be better at thinking about the best language when I'm back in my office alone. But that's how I would write it, I think, is what the proposal is. Yes.
Just so I understand, it would be just victim records, not records,
Correct.
quote, about or concerning the victim.
I think you still need that language, but you're limiting it to a Rule 17A F record. Right. Because it's not the victim's own record. Like I said, they're possessed by third parties.
If the victim were being subpoenaed directly for records that were in their possession, they already have the notice and they already have the ability to file a motion to quash. The issue that we're trying to address is currently the 17A process that plays out when records are held by a third party provider, like cell phone records or counseling records or medical records. The victim is not consistently given notice that these records are being brought into the proceeding as an issue, that there's been a request for them, the court is considering authorizing a subpoena for them, or that they have any sort of ability to provide information to the court that might impact that request. The provider that holds the records concerning the victim, their cell phone records, their counseling records, their medical records, is provided notice and given an opportunity to be heard. Quite frequently, medical providers are not actually electing to be heard in these proceedings about or concerning this privileged or protected documentary evidence. They're sending form letters to the court with token objections. And the state's attorney is consistently in these proceedings being told by judicial officers they have no standing to be heard on these requests. So all that's being engaged in is an exchange between a defense counsel and a judge about a broad swath of records that are being sought and with increasing frequency for crime victim records in our courts.
I have an idea. I don't know if it helps. So I could clarify in here, if you all like this idea, that's a subpoena issued to someone other than the victim for a record that implicates a privilege, confidentiality protection, or privacy protection under federal or Maine law held by the victim as described in Rule 17A, subsection F. So that it's clear we're talking about the victim's privileges or confidentiality protections provided by law but we don't use that record about or concerning the victim, which I can see is very troubling.
Representative Sinclair.
That sounds way better. I wanted to make sure that if, for example, defense attorney in watching discovery that was provided sees that an officer is using a personal cell phone, records from which weren't provided, I wanted to make sure that that defense counsel could still subpoena those records without having to also go through the mechanism of providing notice to the victim about that, because having that person have a voice in those proceedings didn't make sense to me. Doesn't make sense to me.
Representative Kuhn.
Thank you. Janet, when you're ready, can you just repeat that again? I want to make sure I'm processing all the
So,
components.
I'm not sure of the exact language.
Yep.
And I'll probably ask for permission to work with Shira on it, maybe if she doesn't mind. But it would be a subpoena that's not to the victim, since we know that they already get the notice that way. So it's a subpoena not to the victim, but that implicates a privilege or confidentiality protection possessed by the victim that is implicated as described in Rule 17A-F. Because that talks about, because if there is, for example, a health provider privilege, that privilege is not held by the health provider, it's the victim's privilege, so it's their privilege that we're talking about.
Anything else, committee members, on this particular aspect of the proposed amendment? Not, oh, yes, Representative Henderson?
Thank you, Madam Chair. In your first iteration of that proposed language, I'll wait till you're done writing, Janet.
Oh, no, it's okay, thanks.
Your first iteration of the proposed changes, you use the term held by a third party. The second iteration didn't include that. Was that just?
So it's not, I think it would be better, it's going to have the same effect, or you better say a subpoena that's not to the victim,
Okay.
which means it has to be to somebody else.
Okay.
Because if it is to the victim, Andrew Mancuso mentioned that they will get notice anyway, so we don't need to add in that the prosecutor also has to tell them.
Okay. Thank you.
Other comments, questions, concerns, discussion, motion? Representative Henderson.
Before motion, I did have one other thing that I wanted to just kind of flush out a little bit. And I hit on it in the first work session. And I probably got a good answer, but I don't recall what the answer was. In section 5H, the right to receive timely notice or to have an opportunity to be heard at any criminal hearing or criminal court proceeding.
Concerning.
Right, concerning a subpoena issued for records about or concerning the victim, and we got new language there. Am I right, and I guess this is a question to the committee and maybe the attorneys on the committee, to have a concern that the term any criminal hearing or criminal court proceeding concerning this, could that encompass many proceedings, whether it be the original proceeding on whether or not to have a subpoena or an appeal, like how many of these criminal proceedings could there potentially be concerning this?
I believe the answer last time was 2, the first time the request is made, and then when the records come in and the judge reviews them, but I would defer to phone a friend, but I believe that was the answer last.
Okay.
And I guess they might not decide that time. They could say, come back tomorrow, like tabling it.
Right. So no more than 2.
I can't guarantee that, so I
Okay.
would say definitely double check with the folks in the back of the room, but that's what I recall from last.
May we ask someone from the Maine Prosecutors Association?
Yep. Shira Burns, could you please join us and answer that question? Also, thank you very much for being with us this morning.
Shira Burns, Maine Prosecutors Association. Representative Henderson, definitely 2 in theory. Is it always 2? No, because you're in the middle of a hearing and it's 4:00 and you have to end, and then it gets continued. There's continuances, there's stuff that comes up at the hearings, but we're not talking about a ton. These issues sometimes take a while to flesh out. Sometimes they happen just like they're supposed to. You have your initial part of 17A and then you have your second part of 17A. But I can't give you a definite number because it's it flows sometimes, but I will say this is not something where we're having hearings all the time on subpoenas. And it's almost exclusively in domestic violence and sexual assault cases. Happens in other areas, but it's very specific to that case type.
Let's just see if there are any other questions for you while you're with us. Questions for Shira Burns? Yes, go ahead, Representative
And-
O'Halloran.
And it may be something you and Janet are gonna work out. I was just curious if you had any thoughts on the wording that we were talking about under the presence of the victim's attorney and advocate section that we were just discussing.
Are you regarding what the language that Janet
Yeah.
just proposed? I think it's specific. I think Representative St. Clair had a great point, and I think Andrea's suggestion and Janet's words is exactly what the point we're trying to tackle.
Thank you.
Anything else, committee members? Thank you very much.
Thank you.
Does any committee member wish to make a motion to frame our discussion? Representative Lee?
I move ought to pass as amended with the understanding of the language amendments that Janet's going to make to the goldenrod sheet.
Thank you. Would committee, let's see if there's a second, and then I'm just gonna ask Janet to review those changes so that everybody's on the same page. Seconded by Representative O'Halloran. And then Janet, could you please just review those changes for us?
Certainly. So it's all of the changes that are shown already in the goldenrod handout. Plus in both section 5 and section 8. References to the victim's rights to be notified of and an opportunity to be heard at certain subpoena hearings. So, or proceedings about a subpoena request. So these would be subpoenas, as the amendment already says, relate in a criminal case. And then the language we talked would be a subpoena not to the victim that involves a record for which the victim has a privilege or confidentiality protection provided by federal or Maine law within the scope of Rule 17A, subsection F of the Maine Rules of Unified Criminal Procedure. And I would still request that I be able to run that language by Shara, who actually knows about criminal proceedings that I don't.
Thank you. And then it would also include the records related to digital devices
Oh,
or
yes.
whatever the
Thank
that
you.
language would
Yes.
be.
Digital devices as well.
Okay, thank you. Representative Lee?
And also in section 9, do you want me to wait until you're done writing?
Yes. See, I'm glad you did this.
Are you ready for me? Yeah. In section 9,
Yes.
the last sentence? Okay, great.
Yes. So that's going to clarify that it's not up to the victim witness advocate to decide whether to speak on behalf of the victim. It's the victim's choice.
Great, thank you. Senator Hagan?
Thank you. I haven't finished my blueberry muffin, so I'd like to go for 1 minute.
Okay. I think we're gonna take a brief break, and so we'll be at ease for just a moment or two and return shortly. We're back from caucusing and we're still in our work session on LD 2163. We have a motion by Representative Lee and it was seconded by Representative O'Halloran. And then I think we have some additional discussion. Would any committee member wish to engage in additional discussion? Representative Sinclair.
Thank you, Madam Chair. I very, very much want to support this bill. I do not right now intend to support the motion, but could if there were some very minor differences between the motion as presented and what I'd rather support. And the primary difference is in paragraph H, where the word subpoena appears. If instead it said written request, it would be comprehensive of those situations where these records that are equally pertinent to the victim and in which the victim has an equally strong expectation of privacy, it would give them a voice in those instances, not just in the instances that would follow later in the process where a formal subpoena was issued. So I don't know if any other members of the committee are interested in exploring that, but I would like to see victims given voice throughout rather than just in the later stages.
And can I just ask you a follow-up question, Representative Sinclair? Is there a statutory or parallel rule that those requests would be made pursuant to? Or how would that request come about?
There is, I think we talked about it at the last couple of work sessions. If off the top of my head, I think it's 5 MRS 200-E, but I could be, I'm not off this time.
Thank you.
Thank you.
And so do you want to continue addressing this item, Representative Sinclair, now that we have a statute in front of us?
So the comments I made earlier were intended to include the circumstances that are outlined in paragraph 2 of section 200E, title 5. Basically, I want the victim to be able to speak up whenever their private records are being requested by anybody for any purpose.
Thank you. Committee members, are there any comments or questions for Representative Sinclair? Representative Henderson.
Thank you, Madam Chair. This is a question for Representative Sinclair. You indicated, or you just stated that you wanted a victim to have notice when their records were requested at any time, or maybe you didn't say at any time. Are you referring specifically to criminal proceedings? Like within the context of the bill or just in general?
I appreciate I should have asked permission to speak.
You may.
Chair, apologize. I appreciate the clarifying questions. In my mind, we don't normally have, or I don't think of us as having a legal victim except in the instance where there is a criminal proceeding. But you're right. I should have been more clear that I'm only talking about in the course of criminal proceedings. Thank you.
Other questions or comments, Janet?
So these written requests, if we look at 200-E, subsection 2, are either when the criminal proceeding has already happened or been initiated, or it could be during the investigation stage. So that might be an earlier stage than we were originally contemplating with the other subpoenas, I think, but I don't engage in these investigations, so I can't be sure.
Representative O'Halloran?
I have a question and I'll forewarn you, not exactly sure how to word it.
Okay, go ahead.
So I know we eventually on like domestic, we'll just use domestic assault. It became apparent that we had to have mandatory arrests because oftentimes the victims refuse to press charges after the police would come and break things up. So if we're going to, how will this affect? I mean, to me, this seems like it's going backwards, because if we're now going to say that the DA's office cannot get medical records without permission, doesn't that in fact go right back to the beginning, which was proven for decades that victims oftentimes are coerced, and even without coercion, do not have the strength or the courage to move forward until they gain that somewhere through the process. So in my mind, I see this as going backwards, as for something that has been proven to be a fact throughout a long period of time. And I guess I'm not sure how to word that question, but does anybody else see that also as going backwards for victims' rights?
So the great thing is that this is a work session, so you don't have to ask a question. And thank you for making that point. Would any other committee member wish to be heard on this? Representative Pugh.
Thank you, Madam Chair. This is just, I guess, a follow-up to Representative O'Halloran. And a question is that would changing this to written request, that wouldn't require someone to give permission. It would simply be providing notice within the context of the bill, but for both subpoenas and then also these written requests as referenced. Am I understanding that correctly, or is there another mechanism that would require permission?
So I think under this current law, yes, you don't need a subpoena, but it also doesn't involve any court process. So this would now be creating a court process, because I don't think these, and I would defer to the Maine Prosecutors Association on this, I don't think these written requests are covered by Rule 17A right now. So, and it could be during an investigation stage, so it's before the case has begun. So that might create a very rare, I don't know how rare, but situation where a victim does want to challenge it, a potential court hearing where there might not have been one before. Does that make sense? Okay.
Senator Hagan?
Thank you. So I'm at the risk of being confusing to myself. Could I have an explanation as to, from Representative Sinclair or Pugh or Janet, as to the difference legally in a court of law and a criminal proceeding on upon written request versus subpoena? Well, I don't quite, having been a storyteller my whole life, some of these things convolute my brain.
I think Representative Sinclair is prepared to answer your question.
Thank you.
I don't represent that I'm prepared to answer it. I'm prepared to take a swing at answering it. A subpoena is itself a court order. The 17A process is there essentially asking for permission to issue that court order, demanding that someone either A, show up, or B, bring the confidential materials. A written request pursuant to Section 200E that Janet very kindly brought to us, it's just a letter that they write on their letterhead to the hospital saying, please give me all the records you've got for this particular individual for this date or this range of dates. And the victim never gets to hear about it, never gets a voice in saying whether they do or don't want those records released.
I thank you for that. And I just needed a little bit of clarity and I got it. Appreciate it.
Okay, I have a suggestion, which is that, let me recognize Representative Kuhn first.
Thank you. I was just going to say, I think this is an important question to explore, and I don't know if we got all the input on it previously when it came up, and I'm wondering if we can call up a couple of people just to briefly give input on it.
Yeah, that's what was, oh, okay. We're thinking on the same track. So I think it would be, if we could hear from Shira Burns, if you would step forward and share with us your thoughts on this, and then also Andrea Mancuso and also the bill sponsor. Thank you for rejoining us.
Thank you. Shira Burns, Maine Prosecutors Association. First of all, I always thankful for wanting to put a victim's voice into criminal proceedings. I do feel as a prosecutor, they're lost a lot. I do want to clarify one thing that Representative Sinclair just said, and there is a really big difference when we say the word medical records pursuant to 100E and the medical records that are being sought under the 17A process. Right now, under the and I see 17A meaning the main rules of Unified Criminal Procedure. 17A process right now is being used to get vast medical records, vast counseling records. So a victim of sexual assault, and let's say this person was sexually assaulted and goes and gets counseling, which we all hope they do. Their offender, through their defense attorney who's doing their job, is trying to get access to tons of counseling records that could be talking about a lot of different things. And that is something that is worthy in the bill to look at, limit, and give a victim a voice. The 200E statute is very narrowly tailored. They're medical records of the examination and treatment from the actual criminal act. So a victim is beaten and it goes to the hospital. We get those records through 200E. When I say records, the records of that exact care and treatment, not when that victim went and saw the ER 2 years ago, not when the victim is doing the things we hope victims do to get the help. That statute is very narrowly tailored for the specific incidents of evidence of a crime that occurred in that case. No one is going to argue that's not relevant, that it's not admissible. We have a statute and a main rules of evidence that allows that evidence in. Defense and state will, I've never seen an argument, never heard of an argument where that is not specific evidence that's coming in at trial when a victim seeks treatment for that exact crime. So I see a big difference on what the bill is trying to do, the protection it's trying to put in place, to what is being discussed right now with availability of the 200E process, which is very, very narrowly tailored. Now, regarding the actual practical implications of expanding the language as suggested, is we'd be creating a lot more hearings that don't exist. I don't even know how I'd have to think of how it even happen, because these are used in the investigative stages. They can be used later, but they're used in investigative stages, meaning someone may not be charged yet. We're deciding what charges. Sometimes we can't decide the charges because we have to see the medical records to know, does it constitute serious bodily injury? Is it just bodily injury? So what this new language would be, proposed language would be implicating, is suddenly a hearing when a defense attorney is not even on board yet, because there's not maybe even a defendant yet. You're looking to charge a case. So practically, I don't even know how that would work. It would be a lot more resources, I'm assuming, from the judicial branch and the prosecutors. What I have heard on the ground is about the 17A process and letting these victims have a voice. And I hope Andrea can speak next. I have not heard, and I do hear a lot about crime victims, about what is not working in the process. And this has not been a complaint because it is so narrowly tailored. Now, if we gave them a chance to be heard, what would a victim say where the actual medical record of the assault doesn't meet the admissibility, the relevancy? So are we giving victims, again, some kind of false hope that they're going to change a judge's mind when I can't imagine that's debatable, that this isn't evidence of a crime, as what's being sought in the 17A has been debatable. And victims that have been heard in some jurisdictions, there has been judges that have not allowed the certain records. To Representative O'Halloran's point, I hope everybody has had a chance to read the 15th biannual report of the Maine Domestic Homicide Review Panel that was just published. In that, the panel observed that approximately 80% of domestic violence victims recant, not even not participate in the process, not call us back, but actually are recanting. 80% of domestic violence victims are not lying that the abuse didn't happen. They're recanting because power and control exists within these relationships, and they don't stop just because a defendant has been charged. So when a defendant is charged, and we do send out a 200E, I'm using the statute reference letter, what place are we putting the victim in to have to come and say, don't take my medical records? We always have to think of domestic violence in the context of how it plays out, knowing that power and control does exist, and the victim is most at risk when they are leaving their abuser. And that's usually during this time. So I do think we do something called evidence-based prosecution, where we want to successfully prosecute somebody without the need of the victim participating and testifying. And the medical evidence of that specific crime is one of the best pieces of evidence that we have to hold abusers accountable for their choices and to protect our victims as much as a criminal justice system can protect a victim.
Thank you for sharing your thoughts with us about this item that we're discussing. I think committee members, I would like for us to hear from Andrea Mancuso and also the bill sponsor before we dive into questions, because I think it's really important for us to just hear everyone out and then be able to weigh this. Is that okay? Yes, go ahead.
Have you found that women that have gone through the process, like you've used their medical records to give them justice without involving them in that court proceeding, have you found that that in itself gave them the courage to start trying to leave and preparing them to change their life circumstances?
I mean, I feel like I think Andrew would probably have a better sense on this, because sometimes victims leaving their abuser is actually more dangerous than them staying. But I can think of two very specific cases where I had trials where the victims did not testify. Both defendants did get what I consider a lengthy sentence. They both were over 5 years. And the victim did call us, which I just don't really hear from victims after, and talked how the time that the amount of time the defendant was sentenced to gave them enough time to put them in a situation where they were successfully able to leave that relationship in a safe manner up until that point, and did thank me for being able to do what I did without their participation. And both of those definitely were very medical records related cases. And I don't want to do a false impression that that happens all the time, because that's not accurate.
Other questions for Shira Burns? Yes, Representative Henderson.
Thank you, Madam Chair. I am compelled once again to remind you I'm not an attorney. So as I read 200E, paragraph 2, it appears as though this creates permission for the AG's office to make these requests, as well as grants them authority to make the requests. Where it seems as though that, at least what I understand, the intent of the bill is not to grant authority to the requester, but simply to ensure that if a requester is making the request, that the victim be notified and have an opportunity to be heard. Am I seeing that it could potentially complicate and create and maybe an imbalance, or create an authority for whoever's requesting this information, that they would have to provide it if we're using 200E paragraph 2? Because it says, upon written request, whoever the request is made of shall immediately provide the authorized person with all medical records. So if we were to use the language here and plop it into section 5, or strategically place it, because Janet doesn't plop anything, into section 5, would that be great? Like, giving more permission or more authority than what the original intent of the bill is?
Yes, you definitely don't want to plop 200E to carefully place into the bill, because they are very different. The 200E2, what happens right now is actually my district. When I was in York County, literally my district attorney gave me, specifically me, written permission as a designee to send a letter under pursuant to 200E to a medical provider, who then does have to give me the very limited medical records of that. That process is not the same process as 17A. And I don't think anybody would be advocating that to be the 17A process.
Did I misinterpret then what the intent was? Is it just to add upon written request? Or was it to add, I guess this question is for maybe Janet or Representative Sinclair, to add shall immediately provide authorized person? Or was it just to kind of create a parallel upon about the written request versus subpoena?
Right. Can we defer that until we've heard from everybody, just because the proposal from Representative Sinclair, for example, may change over time?
Is there an actual proposal from him right now? Is it this?
My understanding was that it was to include not just subpoenas as the bill is written, but written requests under this statute.
Under the statute. Okay, thank you.
So you wouldn't have to write shall immediately provide, you would just, the statute right now says they have to immediately provide it. That would, by doing this, go away, because instead of immediately providing, there'd have to first be notice and an opportunity for the victim to be heard. So there wouldn't be an immediate provision of the record anymore.
We're all set, Representative Henderson, for now?
As much as I'm permitted to be, yes. Thank you.
Thank you very much. Could we hear from Andrea Mancuso next?
Good morning again. Is there a particular question, or you just like me to pontificate on the
No,
suggestion?
well, we don't want you to pontificate. We'd like you to share with us your thoughts on whether amending this legislation to include the 200E procedure is part of the intent of bringing the legislation forward, or is it outside of the scope of the legislation? And then what impact would it have on the overall work of protecting victims of domestic violence?
It's so far outside the scope of what the intention of the bill is that it's stunning. The false equivalency here that's being drawn is quite unfortunate from my perspective. And if you were to put this procedural impairment at the front end of domestic violence prosecution, you would be doing decades of unwinding of how we prosecute domestic violence cases. Shira has given you a tee up around best practice for domestic violence prosecution across the country is something we call evidence-based prosecution. What we essentially encourage prosecutors to do is look at prosecuting domestic violence cases as if they're homicide cases. We encourage prosecutors to get evidence of the crimes committed in intimate partner violence, particularly assaultive violence, outside of needing to rely on direct testimony from a victim. That is that medical record. 200E is exceedingly narrow. It is the medical record that exists about the incident. If I punch you in the face and you go to the hospital, that's the record that the prosecutor gets under 200E. The prosecutor is not getting the other 10 times that you've been seen at that hospital. They're not getting the years of therapeutic records that we're seeing defense attorneys try to get, that this bill is meant to address. The timing of this is also something that you should be aware of in terms of how victims engage with and are supported by the criminal justice process. These records are they're obtained by prosecutors, as Janet has noted correctly, a lot of times in the investigation phase, before trial happens, before arraignment happens, before arrest happens. It's exceedingly early. The victim witness advocate might not be in touch with a victim until just before an arraignment. The supports are very frequently not in place for victims unless they've been independently working with one of our centers at this early stage when these records are trying to be obtained. To the point Representative Henderson keeps bringing forward, I think this would add a court proceeding, something that people have to show up at. So we're then looking at likely a fiscal note for the bill. The false equivalency that is being made between what the prosecutors get on a narrow road in 2000 and 200 and what the bill is meant to address couldn't be larger.
The question for you, is the narrow scope of the 200E request reflected in a narrow definition of the term medical records in that statute?
Yes, and medical.
Can you please read that? Because when I looked at paragraph 2, I was like, oh, wow, medical records, that seems like a lot. But if you start at the beginning, which I finally did, it hits me differently. So could you read the definition of medical records?
Sure. Medical records means all records of the examination or treatment of a person relating to the alleged criminal act in whatever medium preserved, including but not limited to records that are made confidential by any other provision of law. And I think the important limiting language there to look at is relating to the alleged criminal act. They're exclusively concerning the act. And to Attorney Burns' point, there isn't a court, once someone is charged with a crime, that is going to find these records to be not relevant. Both parties, the state and the defense, are going to get these medical records as relevant to the proceeding. So you would be, in fact, giving notice and opportunity to be heard to a victim to come in and potentially object without there really being any sort of reality at the end of that a judge would say they're not relevant to be turned over. If you have a defendant charged with this assault, they're going to get the medical records concerning the assault.
Thank you. Let's see if there are any committee questions, committee members. Representative Henderson.
Thank you, Madam Chair. It seems, and I could be wrong, that your objection to this, or part of your objection to this, is the right to be heard. Would you have any objection if this piece specifically was just simply about notice?
If the prosecutors had to give notice that they had collected the records?
And not just a written notice, not preemptively when there's a written notice, but once they've received it.
I mean, I will say, I think it's the practice of the state. The victims know the state has gotten these records pretty consistently. I mean, they're working with, particularly in cases involving assault, there's almost all the districts have victim witness advocates that prioritize working with victims of assault crimes. And that's sort of a natural information exchange in talking with a crime victim. The victim witness advocate's going to let them know, you know, what the prosecutor is looking at, you know, what, I think they know that already, that the state has gotten them. I think there would be problems if you're putting prerequisites on the state's ability to get that. I think for domestic violence cases in particular, you should understand the coercive nature of the communication with a victim to try and get that person to not cooperate with prosecution, not only by the defendant, but by defendant relatives, by common friends. This would do harm to domestic violence prosecution. The point of the bill is to try and decrease the trauma that victims experience with these wide swath record requests that we're seeing with increasing frequency, not just in one prosecutorial district, not just in two, but across the state. By attaching, you'd be attaching, this is a solution in search of a problem. I have worked with crime victims for 20 years, and I have never had a crime victim. And I work exclusively with domestic violence and sexual assault cases, which are the cases in which these wide swath records are being requested. I've never had a victim who is upset that the state got their medical record for the assault that happened against them as part of the prosecution.
Representative Lee.
When I was sort of thinking this through, I was like, okay, with respect to a subpoena, there's an obvious process once someone receives notice to attempt to quash that subpoena. with respect to the 200E, is there a parallel process? I mean, there is no, as I understand it, there is no real process here because it's a request and then it's a receipt of a document. So we'd be inserting a process that doesn't presently exist, right?
Right.
And are there also confidentiality provisions in 200E that limit who gets to see the documents?
Yes, that I believe is in subparagraph 4.
Can you just let us know what those are, please?
Sure, and Shira might be the better person to talk about. They may not be disseminated to any other person other than by order of the court or to a member of the staff or an other authorized person, a law enforcement officer specifically assigned to the criminal proceeding or investigation, or another person who by virtue of special knowledge or training is designated by the authorized person to assist in the performance of the authorized person's duty in the criminal proceeding or investigation. I think also they'd be required to be turned over as discovery to a defendant anyway,
In addition to what's in there.
in addition to. what's
Thank
here.
you. I'm just going to ask if there are any other questions for Andrea Mancuso. Yes, Representative O'Halloran?
Just for clarity, so we're all understanding. Do you feel that our current motion is what you need to protect victims, or do you think we need to consider adding Representative Sinclair's thoughts into the bill?
I would encourage every member of this committee to support the pending motion without amendment.
Thank you.
Any other questions for Andrea Mancuso? I'm not seeing any. Thank you.
Thank you.
Then this is a question for the bill sponsor. Do you wish to be heard on this? Yes, okay. Please join us. Thank you.
Rep. Gramlich, Old Orchard Beach. Thank you for the opportunity. I don't have anything necessarily to add to what Shira and Andrea said, except I do want to underscore relative to section 200E. Again, this is what we're talking about, very specific to a criminal act. I think 17A allows victims to have their voice heard, and to that end, quite candidly, if we really want to understand what is important to victims, we should be listening to what the victims are telling us relative to what they've endured. It's no secret to anybody on this committee what I myself have endured as a survivor of childhood sexual abuse. However, what people on this committee and in the legislature, now that I'm airing this out loud, may not know is that I'm also a survivor of domestic abuse, not only in my first marriage, but also as a child. And so I know firsthand what my mother went through. And the stories that you just heard from our advocates behind us about being pressured to recant when you come forward is a reality that I lived through as a child every single day with my mother. So I just wanted to be on record for saying the importance of this bill is to really give voice to victims. And if we are really concerned with what victims need, we should be listening to them. And I underscore again, and will echo what Ms. Mancuso said relative to supporting the pending motion as written. Thank you very much.
Thank you. Committee members, any questions for Representative Gramlich? I'm not seeing any. Thank you.
Thank you, Madam Chair.
Committee members, is there any additional information that people would like to have before we move on to committee discussion and a vote on the pending motion? Any committee member wish to engage in discussion as we move toward a vote on the pending motion? Representative Henderson.
Thank you, Madam Chair. I just wanted to thank Representative Sinclair for his thoughtfulness on this. And I trust that the intent behind the suggestion was to ensure that victims had a robust voice during the entire process. So I will be supporting the pending motion.
Any other discussion? Representative Kuhn?
Thank you. I will also be supporting the pending motion. I think we have a narrowly tailored solution to a specific problem in front of us, and I am hesitant to go beyond the scope of that when we're hearing that there are also significant downsides to expanding the scope. So I'm going to be supporting the pending motion.
Other discussion, committee members? Yes, Representative Poirier.
Thank you, Madam Chair. I just want to say real quick for all the advocacy groups that have come to speak to us, I just really appreciate you bringing these things forward because it's extremely important to me that victims of these abuses are seen, they're heard, and our job is to help take care of them. In essence, I mean, to help them through this tragic events in their life. And I think it's very important that we're not in the process of putting legislation through re-traumatizing people. So I just want to say I really appreciate the sensitivity and sensible actions you put before us. Thank you.
Representative Sinclair?
Thank you, Madam Chair. I appreciate the continued conversation and contributions of all the folks who have come to be with us as we work on this bill. And I particularly appreciate Representative Gramlich's just openness and candor and sharing about her experiences. If we give voice to victims in the way that I am hoping this committee will, those who want to proceed won't choose to exercise that voice, or frankly might show up and say, good God, yes, please give them access to the records, in which case there's no impediment. I get that the advocates that work with folks who have been victimized, I get that they will hear that this will help them in working with those individuals. In my 17 years of doing this work, I, not frequently, but it's also not a rare happenstance, have heard from the named victim who feels victimized not by the person charged, but instead by the process itself. I have heard people come to my office to talk with me about allegations made against an intimate partner, against their spouse, who are not able to have contact with that spouse, who are shocked that these confidential records, and I frankly believe that any individual has just as valid and just as enduring a confidentiality interest in protecting their private medical information, regardless of who it is that's looking to get it from the holder of that information. I hear from these people that their lives have been turned upside down. Guess what? I don't hear from named victims in the instances where they actually feel they are victims. They don't want to work with us in the same way as people who are named as victims, but don't feel that they were in the charged act, don't want to work with the VWAs. So to my mind, it is just as important to give people who are named as victims in a criminal proceeding a voice, just a simple voice over the proceedings related to their confidential information, regardless of which party to the action is looking for it. Like I said before, I'm on ought to pass as amended, just slightly differently amended.
Anything else, committee members? Representative O'Halloran?
I have a question for Representative Sinclair, and it is meant with all sincerity. By listening to what you're saying, do you also believe that victims should be able to refuse prosecution when the police arrive and are disrupting those domestic assaults, irregardless of what physical condition they're left in?
So I think that is not germane to the bill before us.
I can see how you say that, but I can also see how it is, because ultimately what he's advocating for is doing the same thing. If they don't have the right to prosecute the crime without the help of the victim, but to punish the abuser, to protect the victims that aren't able to represent themselves for a myriad of physical, emotional, mental health reasons, that helps everybody in society, but it especially helps them. And I personally equate it to the same thing as it used to be before we had laws of mandatory, arrest and prosecution. So it really, to me, when I break it down on a very simple level, because that's where I live, it is the same thing as when the police officer shows up, the husband or partner or whatever is beating the life out of this person, and, you know, also putting themselves in danger and wrestling with these people. And then the victims would say, no, I don't want to prosecute. And police officers' hands were tied. They couldn't prosecute. And sometimes they go weekly or monthly or regularly. I mean, everybody in the law enforcement community would know the houses. So if you take this into consideration, in my opinion, that is the same thing, because it is 100% tying the hands of prosecution to be able to punish the crime without the victim's input, which doesn't help anybody in society, because these people move on or they just stay and keep abusing the victim. So when I break it down, it is the exact same scenario for me. So I do feel it's relevant.
I think that your argument that there's a parallel is germane. I just think that you forcing another legislator to take a stand on that is not germane. Representative Sinclair.
Thank you, Madam Chair. I don't feel at all forced. I'm happy to answer the question and to answer it simply and directly. No, I don't want victims to be the ones who have to decide whether a charge is brought. I don't want them to be the ones to have to decide. And here I'm using the word victims, meaning the person who is named by the state as a victim of an incident. I don't want them to have any of those responsibilities put on them. In the context of this conversation about this bill, what I want them to have is more of a voice in terms of figuring out who gets to look at their confidential medical information and nothing further.
Thank you. Anything else, committee members? Yes, Representative Caruso.
Thank you, Madam Chair. I just wanted to say that I concur with Representative Poirier's statements. I don't have to repeat it, but I'm just grateful for the advocates for bringing forth this legislation. I will support the motion. I would have supported more had it been in there, but I'm glad to be able to do this at this point in time. Thank you.
Any other discussion, committee members, before we move on for a vote? Yes, Representative Sato.
Thank you, Madam Chair. I'll just share that this has been a second time in this committee where we have a discussion on a bill over multiple work sessions, where we hear information from the previous work session that is very, very different than what we hear in the next work session. And I think that it's very frustrating as a legislator to try to make decisions on policy that impacts so many people and folks that are in the most vulnerable time of their lives, that this has happened more than once. And because I think my goal in the policy in this particular subject area around domestic violence and also sexual assault is to always be as trauma informed as possible, to be behind the victims and survivors as much as possible. And sometimes it feels like we're wading through smoke and mirrors to figure out what that is. And so I flipped back and forth between the two reports multiple times. And I'll say it's a 51-49 decision that I'm making right now to support the pending motion. But I really appreciate everyone's work in this field, and I know that it is a very nuanced and complex issue every time that we talk about survivors' rights. So I'm really grateful for everyone who's put so much work into this. Thank you.
Thank you. Anything else, committee, before we move on to a vote? Not seeing anything. Thank you, Clerk Panet.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Representative Kuhn.
Yes.
Representative Kuhn votes yes. Senator Hagan.
Yes.
Senator Hagan votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Sinclair.
No.
Representative Sinclair votes no. Representative Pugh.
Yes.
Representative Pugh votes yes. Representative Henderson.
Yes.
Representative Henderson votes yes. Representative O'Halloran.
Yes.
Representative O'Halloran votes yes. Senator Talbot Ross. Representative Lee.
Yes.
Representative Lee votes yes. Representative Sato.
Yes.
Representative Sato votes yes. Representative Babin.
Yes.
Representative Babin votes yes. Representative Caruso.
Yes.
Representative Caruso votes yes. Representative Dana. I'll recall the absentees. Senator Talbot Ross. Senator Talbot Ross is absent. Representative Dana. Representative Dana is absent. Madam Chair, I have 11 members voting in the affirmative, 1 in the negative, 2 members are absent. That is the vote of the committee.
Thank you very much. Representative Sinclair, did you want to articulate your report, please?
Just what I said it would be earlier, Madam Chair, ought to pass as amended with the slight change, changing from subpoena to written request.
Thank you.
Do you mind if I include both subpoena and written request? Okay, I may also just, as a warning, I'll bring back preliminary language. Have to slightly amend 200E to make it clear you don't give the record until you know whether this opportunity to be heard has been invoked.
All right, thank you. And I think with that, we're done the work session on LD 2163. Thank you so much, everyone, for your participation today. I know that we have a lot of folks here for our second bill, LD 2121. Committee members just need a very short stretch break. So if we can resume our work at 12, we'll just be in recess very briefly until 12. Hello, everybody. Welcome back from our brief break. We're going to start the work session on LD 2121. And Janet, can I just turn it over to you, please?
Certainly. So LD 2121 is an act to enhance the safety of judicial and elected officials, constitutional officers, and the state auditor by allowing certain personal information to be removed from designated public records. And right now, the bill analysis is being distributed, which does focus on the bill as written. The sponsor's amendment is completely different. So I don't mind just skipping over the bill analysis and looking at the sponsor's amendment. And then if anybody prefers the original bill, we can go back and go through like the questions that came up there, if that makes more sense.
Yeah, thank you for that suggestion. Committee members, is everybody comfortable proceeding in that manner? Okay. So we'll focus just on the sponsor's proposed amendment.
Okay, I think, do you have the yellow handout yet? Nope, it's the second handout, so I'm gonna wait till you get it.
Thank you.
So the yellow sheet is the sponsor's proposed amendment for this work session. And I'm happy to go through it, or you can have the sponsor go through it. I see he's here today.
Could the sponsor please join us at the horseshoe? And let us know whether you would like to go through it with us or if you would prefer Janet to do so.
Thank you, Senator Carney and Representative Kuhn and members of the Judiciary Committee. I'm happy to defer to Janet.
Certainly. So this, if you remember just very briefly, the original bill created a process for redaction of the home addresses of certain elected and then judicial officials from different types of government records and websites. And there were lots of questions raised about it. So it's my understanding that the sponsor believes that more study needs to happen of how those questions could be resolved, including whether data brokers should be restricted in their publication of home addresses and how you can even tackle that problem. So the amendment would replace the text of the bill with a resolve that would do two things. The first is direct the Department of the Secretary of State to convene a working group of stakeholders to really dig into these issues. And the issues are to examine threats of violence currently faced by judicial officers and elected officials in this state, and then legislative approaches in other states to enhance the safety of similar officials, including legislation about removing certain personally identifying information, including home addresses, from different types of government records, and the logistical, financial, technological, and other requirements that would occur if you were to try and take such an approach. And then also whether and how to deal with data brokers who may already have this information before you take it off a public website, and how you address that issue. And so the folks that the Secretary of State would be directed to include in the working group, although the Secretary of State could absolutely include other folks, include those in the list here in 1A through J. So the Secretary of State obviously would be involved, a judge from one of the state courts appointed by the Chief Justice, and then a representative of the Administrative Office of the Courts, as well as a county probate judge. That says new with an arrow because the first version I said to you didn't have that. Instead of cluttering your inbox with another version, I just thought I'd point it out today. Also, the Commissioner of Public Safety or designee, the Chief Information Officer or the designee, Attorney General or designee, at least one Register of Deeds in the state, because we did have testimony about how the way that the registry system works is very name-based, so it might be difficult or complicated to figure out how to address those issues. a representative from Maine Municipal Association, and a representative from the Right to Know Advisory Committee. Stapled to this sheet, because when I sent out the proposed amendment, I sent it to the interested parties list and to you all, is a response from the Maine Press Association asking that you direct the Secretary of State to include a representative of the press in the working group. So that's up to you. Now, you may be wondering, why is this drafted this way? Because you didn't hear me say legislators. And those are specifically part of the people whose addresses you want to protect. So the language below in this sort of unnumbered paragraph says that the Department of the Secretary of State should invite the participation of and input from members of the legislature, including from each of the two parties. And the reason it's drafted this way, it was my understanding that the sponsor hopes that this not be a legislative study or use legislative resources and therefore have to go through the legislative study process. So if you make the Department of the Secretary of State include legislators and they travel to the meetings, their expenses will be reimbursed. And that puts this as a use of legislative resources and within the ambit of the study table. I cannot guarantee drafting it this way takes it off that process, but it is the attempt to do so. And I believe that there were discussions that they don't mind me sharing that there's no reason why a legislator couldn't attend by Zoom and therefore not be incurring travel expenses that would need to be compensated. Okay, so that's the first section, is this working group. The second section is to have a pilot project where the Secretary of State would allow folks who are covered, so these are your judicial officers or legislators, to opt in to having a 2-year subscription to a service like Delete Me was the example I was given, which kind of goes through and tries to scrub your home address from or personal information from different websites across the internet. And I don't understand the technology of that. You may remember from data privacy. I know the law is not the world, so you'll have to ask someone else about that. And then there would be a report that would come back to the next iteration of this committee, February 1st of next year, which talks about how the pilot project is going and then gives the report of the working group and what their recommendations might be for moving forward.
Thank you very much. To the bill sponsor, Representative Faircloth, do you have anything you'd like to add?
That was an excellent summary. Thank you again, Mr. Chairs and members of the committee. The only thing I would add is with the February 1st report that we'd be looking to, see what has already occurred with regard to data brokers, but also have an analysis of implementation with regard to public records issues as well, and have that ready to present. And as was already described, we're trying to find ways to make this avoid fiscal issues and move forward with the analysis.
Thank you. And could you also let us know how you feel about including a representative of the press in the working group?
Sure. I think in drafting, this was collaboration with the Secretary of State's office and the Judicial Department, that perhaps that could be covered by what I have as which might be slightly different, but the Right to Know Advisory Committee is what we were thinking as a possibility that would cover that viewpoint. But I think I'm amenable to modification if that's, something that's important for the support of the committee.
Representative Henderson.
Thank you, Madam Chair. Thank you for the amendment, Representative Faircloth. Would you, so it seems as though that they purposely don't have a member of the legislature on the working group, which I like. Would you be amenable under J, representative from a Right to Know Advisory Committee, to specify that they are a non-legislative member?
So the member from J is a non-legislative, yeah, is that what you're? Yeah.
Right, J, that
Yeah.
representative, because there are 2 legislators that currently sit on the Right to Know. If we were determined that it would be non-legislative members from the Right to Know.
That actually makes sense to me because of the sentence in the next line below. So yes, okay. Thank you.
On that same topic, the Right to Know Advisory Committee has a lot of people with like technological experience and other data privacy type experience. So there's many choices, and so it might not be the representative of the media from the Right to Know Committee who would be the most, who would be selected. So in light of that kind of broader understanding of the Right to Know Committee, how would you feel about including a representative of the media?
That would be fine with me. I don't want that to be an impediment of
Thank
getting
you.
this project moving.
Representative Kuhn.
I was wondering if in 1D, we wanted to remove the word county in hopes that the probate court is being integrated into the judicial branch.
They would still be county judges when this working group meets, just. So
Of course. Okay, thank you. Yes.
I like your positive thinking though. Senator Talbot Ross.
Hi, welcome and good afternoon. My name is Rachel Talbot Ross. I represent Senate District 28, which is on the peninsula of Portland. I'm gonna beg to differ with my good representative. I see each branch of government, judicial and executive branch. I also see municipal representation here. The one branch of government that is not represented as a voting member on this is the legislative branch. And I can tell you from personal experience, having not had, having threats of violence, against me even the 10 years I've been here, to just think that we would be invited to participate in a process without a vote makes me extremely nervous. It says shall invite, which is a must, but membership on the working group is really important to me, to make sure each branch of government is represented. And I understand the competition for study table monies, but that's not enough to sway me to not put good policy forward. And it really does disturb me that the one branch of government, which we have seen an increase in threats of violence, certainly the ways in which harassment of legislators has occurred on social media in this state means that I probably wouldn't be able to support this without including the legislative branch and having representation there.
Janet?
So I just want to be clear because the way I structured it could be a my fault thing. Looks like a legislative study resolve, kind of, which does in fact list who's a voting member. The intent of the language is not to say who gets a vote, but just to say who at a minimum has to be included. And just the way it's written about including legislators is slightly different, so as to not trigger the study table, which doesn't mean you shouldn't change it. I just want to be clear. So there's nothing in here prohibiting the Secretary of State from allowing a legislator who participates to vote if they even take votes. There's nothing requiring them to take votes. It's just to convene a working group, if that makes sense. That may not be satisfactory. I just want to be clear what it says.
Yeah, I'm going to give the bill sponsor a chance to react to that as well.
Well, I admit fully that the way it was written was with the hope of avoiding, the fiscal issue. I'm amenable to what I want to do is see this issue addressed. And I do want to acknowledge and underscore your point, because that's my original point, is exactly that, the increase in threats against legislators, as I think I testified at the public hearing, literally documented by the Capitol Police, has been exponential in growth, not arithmetic. So there's a real reason, and I understand and recognize your point. Admittedly, as has been referenced, the strategy was merely with the idea of making it more likely that we wouldn't face an impediment because of the fiscal issue. But I want to do the right thing, and I want to make sure that we get this going. And that was the only holdup. And I think the way it's crafted may be able to get over that hump. But if you're not comfortable and the committee's not comfortable, I'm willing to adjust and take our chances, if there's a fiscal impact.
Yeah.
Senator Talbot Ross?
Thank you, Madam Chair. I understand all of that. I know how the study table works. I know how strategy works in order to get your bill over the line. I get all that, and I totally respect it. But I don't know who the Secretary of State is going to be when this bill is enacted. And for me to rely upon any Secretary of State to include legislators would be fairly discretionable, and I'm not comfortable with that. I really believe that the legislative branch has to be represented on this committee. And I'll leave it at that. Thank you.
Representative Lee.
I'm still mulling whether I think it should be legislative committee or not, but I'm curious if whether the fiscal problem that you're solving in section 1 doesn't create a new fiscal problem in section 2 by having to pay for all of those subscriptions, because it seems like it's any member of the judicial branch or the legislative branch can apply for one. Am I missing something?
I think there might be a fiscal impact of, and we might want to invite folks from the Secretary of State, to see if they had contemplated that as well.
Any other questions of the bill sponsor at this time? Any other thoughts you'd like to share with us, Representative?
Well, with great hope and respect, Madam Chairs and members of the committee, I'm simply looking for the pathway forward. And I totally acknowledge your point, Senator, that to me, my first instinct is, of course, have it straight up. No chaser, that there's legislators involved in this process. But I'm, as part of a team, if you will, in discussions with the Secretary of State's office and the judicial branch, came up with this possibility. I'm totally amenable to whatever we can work together to get this across the finish line, because that's where I really feel passionately, and including with the judicial branch, because they too have faced increased physical threats, so it's significant for both electeds and so whatever pathway we can achieve, I'm eager to adjust to achieve that. I'd certainly want to welcome their comments about any technical concerns they have, but that's where I am.
Thank you very much. At this point, committee members, I would like to call up somebody from the Secretary of State's office. Are there any more questions for the sponsor? No, okay, thank you.
Thank you.
Could we have a representative from the Office of the Secretary of State, please? Welcome.
Good afternoon. I'm Deputy Secretary of State Emily Cook, the Senior Policy Advisor for the department. We have begun work on the fiscal note, and based on our research for what subscription for each year might cost for the covered population being judicial officers and current legislators, it's about 60,000 each year.
I'm sorry, can you say that again?
About 60,000 each year if everyone signed up.
Per person or no?
Total.
Total, okay. I was like, wow.
That would be vastly
Thank you
different.
for the clarification. Thank you. Now that we've all had a laugh at my assumption, are there any questions for the Deputy Secretary of State? Representative Lee.
Was consideration given to maybe narrowing the number so as to reduce that fiscal note for the pilot project?
So that is based on only current legislators. I know in the initial bill, there was discussion over whether or not a program should cover legislators even after they're out, or immediate family members or others. So this is based on just current legislators and the judicial officers. Our research found these subscriptions can be about $200 a year for a person. Of course, we would go out for RFP, look for if there's like a bulk purchasing option. So 60,000 is likely to be the high end of that estimate.
Additional questions for the Deputy Secretary of State? Senator Talbot Ross?
Just a clarifying question. So if the Secretary of State's office is staffing the work group?
Yes, we are prepared to do that.
So if the Secretary of State's office is staffing the work group and OPLA is not staffing the work group, we still couldn't you add the cost of legislative reimbursement?
So
Into-
it's my understanding that the study table, things that are flagged as potentially going to the study table, either because it uses OBLA staffing, which this would not do, or because it uses other legislative resources. And if you formally name that a legislator has to be included on the working group and might travel to that meeting, they would have to be reimbursed. And that is a legislative resource because it comes out of the legislative account.
Yeah, I just seen bills, I've written some myself, that that allow for resources to come from a different pocket of money to be used to advance working groups initiative, and legislators have been on it. So
Yes, if
we
we
did
identify a
that with
different
the-
source, yes.
we did that with the very first Criminal Records Review Committee, is that we wrote in because we had a funder for $3,000. But at any rate, if the Secretary of State is convening the group and staffing the group, I thought that there may be a small loophole there that would allow us not to have the Legislative Council approve it, but not have to fund it. Anyway.
Yeah, that's certainly possible if we identify a funding source. Yep.
Other questions for the Deputy Secretary of State? Representative Lee.
Procedural question, so it's sort of like a joint Janet, Emily affair. If this gets the 60,000-ish fiscal note, goes to the table, doesn't get funded for the pilot project, would the working group still commence?
That would depend on whether somebody proposed a study table amendment, which would strip the pilot project out of the amendment and just leave the working group. And if that doesn't have a fiscal note associated with it, then it could come off the table with no fiscal note. But that depends on having an amendment ready to go.
So if this were passed with a legislator as a listed member of the working group, it would go to both the appropriations table and the study table.
It would be eligible to go to both. I don't know how it actually happens when those competing things happen.
Okay.
If it makes it to both places or not.
Okay, thank you.
But our office would probably mention it to the council when they run the study table, that this is also out there, but on the appropriations table, for example.
Thank you. Senator Talbot Ross?
Yeah, Madam Chair, I have a little bit of information because the Criminal Records Review Committee, which was enacted to permanent, had got approved off the AFA table, didn't get approved by the study table because we weren't asking the study table to do anything. It's a permanent commission. And it is now not able to be operational because it didn't go through the study table process for them just to approve it, not to fund it. So we have a quagmire with the CRC. It won't be able to come, it won't be able to meet because we neglected to make sure that both of those two committees approved the purpose. Yeah.
Interesting. Okay, committee members, is there interest in gathering any other information? Or would somebody wish to make a motion to frame our discussion? Representative Kuhn.
Thank you, Madam Chair. I would move ought to pass as amended, adding as Representative K, a member of the press, and adding as L&M, a legislator, one from each chamber and one from each party. So that will get us to an odd number.
So that's a total of 4.
I meant 3 additions, a member of the press and 2 legislators.
Okay, so 1 from each chamber.
And they're bipartisan.
Bipartisan, bicameral.
Yeah.
Understood.
But only 2 total required. So
Yes.
these are required members. There could be more.
Correct.
Okay.
Representative Lee?
I will second that with one adjustment, if you're game for it. As Representative Henderson was noting, the member of the Right to Know Advisory Committee should be a non-legislative member.
Thank you for that correction. Yes.
Okay, so we have a motion and a second. Is there any, thank you very much for being with us this afternoon and this morning. Committee discussion? Representative Henderson.
Thank you, Madam Chair. So I still maintain my position that I'm uncomfortable with a member of the legislature being part of this. And I completely hear, and a lot of what Senator Talbot Ross mentioned resonates with me as well. I think everyone around this horseshoe has been the subject of threats or potential violence. I know I've learned some incredibly creative ways in which people wish to harm me. So I'm completely for having a study on how to make things safer. My concern is that adding a representative of the legislature, although it is a representative that's reflective in what the study's trying to accomplish, it is a member that has a residency clause. It's a residency requirement for their ability or even eligibility to be a legislator, is that they have to reside in the area in which they're representing. So if I were to move forward and even consider supporting this, I not only would not have representative from the legislature, but furthermore, I would remove a county probate judge because they are elected and they also have residency requirements. And I would remove a register of deeds in the state, also elected and also have residency requirements, but would add a rep from the press. And then anything that has to do with home addresses, I would strike that from paragraph 2 and just have personally identifying information. So if the study group wanted to discuss home addresses, they could, but that it would not be the overarching theme as well as other. So removing anyone that's elected from the study, anyone that has a residency requirement from the study.
Thank you. Other discussion, committee members? I would like to just volunteer. I appreciate and hear where you're coming from, Representative Henderson. I think that as legislators, we have public email addresses. We hear through those legislative email addresses, at least the threat that was made against me and other members of this committee came via the legislative email. And I believe that we need to take a 360-degree look at this, the way that these threats impact the functioning of good government in our state. And so I wouldn't want to make the adjustments, although I understand why, to me, your concern about the requirement that people, have addresses that are knowable when they run is, I think, the second step. And this is just to get our hands around what the problem is. And so I'd be supporting the pending motion. Representative Lee?
I 100% also understand. I think if we were to be voting on this as a piece of legislation that dealt with those elected officials right now, I think I would probably be voting the same way you are on it, because I do feel like that public information, particularly when there's a residency requirement, is valuable. I don't see a harm though in studying it. And it's sort of an issue that I think there might be creative solutions that could be surfaced as a consequence of the study. So I'll be supporting the motion.
Let's hear from Representative Kuhn.
I was just going to add one reason that I like to see legislators on studies is then when the results come back, there are people ready to champion the results in the legislature and bring forward legislation to implement a study so that it's not just sort of an academic exercise.
Representative Henderson?
Thank you, Madam Chair. And I hear what you're saying too about there not being any harm in doing a study, and I agree. And that's why I think I'll have a minority report. I struggle with having a study that subscribes, to include removal of the home addresses, public home addresses, and other personally identifying information. It feels as though it elevates the home address piece and then any other personally identifying information, where I think removing that language and just having it be a study of how do we help these electeds, these appointeds on all 3 branches of government execute their jobs in a safe fashion. I think it's more of an objective look if we take out the home address piece.
Senator Talbot Ross?
Thank you, Madam Chair. The only thing I can add is personal experience where my home was targeted more than once. My neighbors got flyers because I lived in their neighborhood. And that's a really important component of it. I mean, so I'm supporting this this motion because not only have I been threatened in my workplace, but I have been threatened multiple times at my home.
And I would just add that the death threat that members of this committee received, we were all at home when we got it. And we didn't know if that person who had threatened to kill us was waiting outside of our homes, for example, when we left that morning for work. And so I do think there's a unique importance to the home address. Representative Sato?
Thank you, Madam Chair. And I also want to uplift what Senator Carney said about a 360 view. And we've seen in many other situations where the home address piece is where is the impetus for the threat, where that is where they're receiving the threat. And that's also we've seen where it's not just a threat, where physical harm has been committed at a home address because it was public. And I think we talk a lot in this committee at sometimes about wanting to remove barriers for people to volunteer for public service. And I think I don't want to see a future where future officials, future Mainers who want to participate in our elective body to not run or to resign or to leave or not run again because they don't feel safe. And I don't think that that's not a future that I want to live in. And I think this working group just starts that conversation.
Representative O'Halloran?
Thank you. I do feel torn because to me residency is so important. You do see lots of situations, whether it's a town council or other things where people are actually not living where they claim to live. And, and I also feel that people have a right, if they feel strongly, to send mailers to your neighbors or anybody else. But there's apps out there that you can plug your name in and that will tell them not only where you live, where you work. Some of them will tell you how much money you make. Some of them will tell you if you have any like convictions and things like that. It automatically links to deeds which have your addresses on them. So I don't know how any of this is going to prevent any of that because there's lots of those apps out there. So I find this, I'm not sure how effective this is going to be.
Well, I think that's why we need to study it. And I would just note that, I mean, within the past year, we've had a legislator and her husband murdered in their home. We've had a legislator and his wife injured in their home heroically while they were protecting their daughter's life. And we've seen the governor of Pennsylvania's home be set on fire with his family in it, including, I believe, minor children. And then also there was recently an act of violence against a judge as well. And I just think that we're living in a very different world where we need to, we're working very hard on behalf of the people of Maine, but we also, and as Representative Sato said, we don't want good people like ourselves to not run for office because we're afraid that our family members will be killed in our homes. And I think that it's really important for us to understand how, if anything, we can prevent that. Representative Senator Ross.
Thank you, Madam Chair. Just for the record, I don't have a problem with people circulating flyers in my neighborhood, policy related. This was harassment of my family. And this was threatening. So just for the record, I don't care about flyers in my neighborhood about LD something or other, or I have a strong opinion. This First Amendment, totally get it. I serve in public office. I'm talking, this bill is about harassment and threat and political violence. And that my neighbors experience because I serve. And that's not okay.
Anything else, committee members? We have a pending motion. Is the committee ready to vote? Appears that we are. Clerk Panett, thank you for calling the vote. Does anybody need the motion restated? Thank you.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Representative Kuhn.
Yes.
Representative Kuhn votes yes. Senator Hagan. Representative Poirier.
No.
Representative Poirier votes no. Representative Sinclair.
Yes.
Representative Sinclair votes yes. Representative Pugh.
Yes.
Representative Pugh votes yes. Representative Henderson.
No.
Representative Henderson votes no. Representative O'Halloran.
Yes.
Representative O'Halloran votes yes. Senator Talbot Ross.
Yes.
Senator Talbot Ross votes yes. Representative Lee.
Yes.
Representative Lee votes yes. Representative Sato.
Yes.
Representative Sato votes yes. Representative Babin.
Yes.
Representative Babin votes yes. Representative Caruso.
No.
Representative Caruso votes no. Representative Dana. I'll recall the absentees. Senator Hagan. Senator Hagan is absent. Representative Dana. Representative Dana is absent. Madam Chair, I have 9 members voting in the affirmative, 3 members voting in the negative, 2 members are absent, and that is the vote of the committee.
Thank you very much. And for those who voted against the motion, what is your report?
Mine is ought not to pass.
And yes, Representative Henderson?
Mine is ought to pass as amended. That would include the removal of, under section 1, paragraph 1D, would remove the county probate court judge, as well as the removal of H, register of deeds. Under J, we would specify that it was a non-legislative member. And K would add a rep from the press. And then under paragraph 2, it would, there's a few different places, but it would remove any mention of home address.
Representative Caruso? Ought not to pass. Thank you. All right. Janet, do you need additional information from us? So we'll close the work session on LD 2121. And the moment we've all been waiting for, we have
It's-
one more
It's not
item
really
this morning.
amendment review, it's report back from BLA.
So as a reminder to committee members, when we acted on LD 517, which is an act regarding synthetic media and campaign advertising, we asked the Veteran and Legal Affairs Committee to weigh in on that legislation, and Representative Kuhn and Janet did meet with that committee, and so they're going to provide us the feedback that we got from that committee.
Want me to go, or are you gonna go?
You're the boss.
Okay. Janet and I had the opportunity to appear before the Veterans and Legal Affairs Committee. Thank you to Janet for going with me. Between the two of us, we were able to answer all of their questions. They did not, they were really looking at how the amended proposal fits into the election laws. They weren't really weighing in on the underlying policy of the bill related to manipulated images, because that's really the part that our committee worked on. And, no formal vote was taken of any kind, but they did offer one suggestion, which I gave a lot of thought to, and then I ended up thinking, I didn't need to address it, but I want to share it with you in case you feel differently. So on page 2 of the amended bill, section 4 includes information about the disclaimer that would be required for materially altered images. And this representative suggested that we change those words that are in capital letters. It's so right now it reads, this communication contains audio, video, and or images that have been manipulated or altered. And they were wondering if we should break that out to 3 different messages. So this communication contains audio that has been manipulated, and this communication contains video that has been manipulated, and this communication contains images that have been manipulated. I ended up deciding not to adopt that solution because this whole section is going to rulemaking, and I felt that those kinds of specifics, that's the whole purpose of the rulemaking, really, is to determine the size of the font and the nature of the font and exactly what words would be included. So I felt comfortable that that concern was going to be addressed. So I didn't see a need to bring an amendment to you. But that was the only suggestion that I recall being raised, and otherwise we've moved ahead.
Thank you. Any questions for Representative Kuhn, committee members? Representative Lee.
I'm just trying to think of that, because what we have here in the legislation is that it prescribes specifically what those words are going to be. And do you think that that flexibility would exist at the rulemaking, given that we're saying the words in the legislation itself?
That's a good point. A secondary consideration is that oftentimes you can have material that contains all those things that have been generated. And so then if we broke out the separate words, then you would end up putting like 3 disclosures on an ad, and then the font is so small that it's not serving a purpose. So I guess for that reason also.
Representative Lee.
I guess what I'm saying is, maybe was there consideration given to just having it in the legislation in addition to any other required disclosure indications, rather than put the quoted bolded phrase that's there at the rulemaking? They can find what the right way to do the disclosure about the communication containing audio, video, and or images that have been.
Yeah, if that's the will of the committee, I don't think that does any harm.
Yeah.
I just didn't feel that it was necessary, but that's a different question. There's certainly no harm in doing that.
Any other comments, questions, committee members? I would just observe, as a policy measure, I would prefer to have the specific language required, because that's precisely what we want to convey. And if we leave it up to the people who are manipulating or altering the images, then I think we would see different language. And I like that it's all contained in one, because then there's a lower burden on production companies as far as they don't have to parse out and weigh and make decisions. They can just put the one disclosure on there. So I wouldn't be in favor of changing it. Representative Lee.
What was the rationale for the
The rationale was that this representative was of the belief that candidates pay per word on a disclosure, and that it would make it less expensive. But I've personally have never heard of that. It's usually just authorized by the candidate, or, whatever the disclosure is. It just appears at the bottom. I've never experienced that with print materials, for example, that additional words cost more money. But I think that was the origin of the person's concern, is that it could save people money, but I'm not sure that's actually a fact.
Representative Sato.
Thank you, Madam Chair. I think I'll just respond to that rationale that in the case where there's audio, video, and images that are altered, wouldn't that actually increase the amount of words that you would have to use if you'd have to put a separate disclaimer for each audio, video, and image? Okay.
Anything else on this, committee members? Are we content with the bill as we voted on it without reconsideration for those who voted for it, the report? Okay, thank you, Janet.
Thank you.
Thank you, Amy. And then I just want to note that it is 12:45. We're scheduled to return for a public hearing at 1. I would like to postpone that public hearing just until 1:15 so that we all have an opportunity to eat some lunch. And so we'll return to the Horseshoe at 1:15 for the public hearing on LD 2219. Thank you, everyone. Welcome back, everyone, to the Joint Standing Committee on the Judiciary. We have one public hearing, which is on LD 2219. It is entitled An Act to Implement the Recommendations of the Right to Know Advisory Committee concerning certain existing public records exceptions. It will be presented by Representative and Co-Chair Amy Kuhn.
Good afternoon. I am before you to introduce LD 2219, an act to implement the recommendations of the Right to Know Advisory Committee. I would request that a member of the Right to Know Advisory Committee perhaps share the contours of this bill. Thank you.
Thank you very much for presenting this legislation. Is there anybody in the committee room who wishes to speak with regard to LD 2219? In favor? Opposed? Neither for nor against? I'm going to take prerogative as the chair. Oh, please join us. Welcome.
Thank you. See a sign up sheet. I did submit this online, so you should already have this in your packets. Senator Carney, Representative Kuhn, and distinguished members of the Judiciary Committee. My name is Rebecca Graham, and I'm the Director of Policy, FOA, and Legislative Affairs for the Department of Public Safety and the Maine State Police. And we are submitting comment only on this bill. We are neither for nor against. While much of the legislation that is contained in the bill does just make some technical changes to the sections of law that govern confidential information, I wanted to bring your attention to the original language, which is amending, I believe it's in section 8 of the bill, Title 29 MSRA 2251, subsection 7A and paragraph C. The original may language that is being struck from the statute was intentionally crafted to be permissive. It was established to allow the Maine State Police to develop a process for handling commercial bulk requests for accident data without overburdening staff resources and also while limiting the extraction of personally identifiable information. The goal was clear. It was to enable access to appropriate data while protecting individuals who were involved in motor vehicle accidents from having their personal information used for direct marketing or unintended purposes. Currently, individual accident reports do contain personally identifiable information, including the names of the parties involved and dates of birth and accident locations and investigating agency details. Those reports are available to the requesters who can provide some known facts and link to the accident and cost $10 a piece. As the personally identifiable information is required to be provided by those involved in an accident, and it's now contained in a statewide database, regardless of which agency conducts the accident investigation. It's also important for us to protect that data because as soon as that database was established, it became clear that it was ripe with information that was desired for marketing purposes, particularly to market services individuals might be seeking post-accident. And that did not seem to be in keeping with what we believe was the legislative intent, which is to show the actions of government, not the individuals who involuntarily act with government in that case. So in 2011, the legislature did add that language that allowed the bulk data requests for information, but would strip out the personally identifiable information and provide the agency discretion in how it manages those releases. And that discretion is really important. We use Info Maine today to allow the extraction. They have an automatic extraction set up and allows an individual to pay a fee process for that. And if they want that personally identifiable information, that $10 fee is cost prohibitive to doing it in a bulk fashion as well. So operationally, the adding or removing the may language in section 8 is unlikely to change anything that's currently in practice. However, it might narrow how the agency can respond in future. For instance, should that database no longer be operational, should they look to seek to move to another provider, the removal of may in that section may require them to continue to do that, or might restrict some other future purpose and other piece of information that we now know is operationally or marketably contained in that bulk data. So just to be clear, that immediate removal does not change anything operationally, but it may limit how the agency responds in future, and that discretion was important and may be important in the future. Finally, the Office of the Attorney General did identify a technical correction they thought may have been needed in Section 1 of the bill under 5 MRSA 1577 subsection 2. That's directly in Section 1 and involves DNA evidence in our crime lab. The department agrees and recommends that technical amendment be adopted. It should be changed from the main rules of evidence to the main rules of criminal procedure, because that is the reason that those DNA records exist within our crime lab. And other than that, I have no other comment. So I would welcome any questions, but really we just focused on those two pieces that interacted.
Thank you. Just so to be clear, you're suggesting that on page 1 of the bill, line 15, the word evidence be stricken and that be changed to criminal procedure?
Yeah, that was the recommendation that
Thank
the
you.
Attorney General had made to us as far as a change, and it wasn't a change that was necessarily already in that section.
And then with regard to section 8, is it, so it doesn't operationally impact you at all if we were to adopt that change at this time?
We don't read it that way. The May language was to allow us to establish that, but not require us to establish that. It is now established. We are unlikely to pivot away from that. But the option of doing that may be something that is needed in future that we can't foresee at this time. So it is removing that discretion, but operationally, we don't think it's going to impact anything in terms of the way it is now.
Thank you. Committee members, I apologize for jumping in with those questions, but are there any additional questions? Seeing none, thank you. Thank you. I would just like to give committee members some background on what this piece of legislation is, unless Representative Henderson, you would like to do so. So when the Right to Know Advisory Committee meets between sessions every year. And there is a schedule of review where there's a subcommittee of the Right to Know Advisory Committee that looks at designated sections of our statutes and basically reviews every confidentiality provision and determines whether that provision should be reviewed in some manner, and also notes where there should be changes that are to comport with the drafting standards that the revisor's office follows. And so this legislation is a culmination of the work that the Right to Know Advisory Committee did on titles 25 through 32 of this year. And so that's why it's presented the way it is. It's just a list of changes, mostly having to do with drafting standards. And if folks have any specific questions regarding any particular section, please feel free to ask Representative Henderson or myself. And the reason I'm suggesting that is it would be my hope that we could finish our public hearing and then move into work session and vote on this bill today if people don't have questions and concerns about it. Yes, Representative Caruso.
Thank you, Madam Chair. With regards to the department's testimony just now, I understand the change for the main rules of evidence to rules of criminal procedure, but I'm trying to catch up on the use of the word may that is no longer in section 8. I guess that's on page 2 of the bill. Could we just go over that? I'm assuming it's because it's taking out the whole line, the whole first sentence. Is that it?
Yes. Representative Henderson.
Not to be pedantic, but I think that the questions might be more appropriate for a work session and not a public hearing, unless you're wanting to engage in discussion right now, which is your prerogative to do as the chair.
I'm going to go ahead and answer the question just because it would be convenient for Representative Caruso to know. And so there are a couple of different drafting standards that changed. And so you'll see that there's sometimes lots of words are stricken, like may not disseminate. Look at section 2, for example, may not publicly disseminate. That's been stricken, and just the statement are confidential is added at the end of that sentence. That's one thing that the Right to Know Advisory Committee has been doing for all statutes. We were using lots of different ways to describe documents as being confidential, and the lack of consistency was confusing and unnecessary. And so the Right to Know Advisory Committee is now choosing to use are confidential instead of one of the many ways that that concept was described. And then the other has to do with disseminate. And I think if you look at like section 7, disseminate is stricken, and disclose is used. And if you look at section 2, release is stricken and disclosure is used. And so it's just a way of standardizing the language so that when we're meaning the same thing, don't disclose it, or it is confidential, we say it that way. And I think that certainly in section 8, you see the shift to are not confidential rather than having it be may publicly disseminate. So may publicly disseminate is two things. It implies that it might be discretionary, although I think that may and shall sometimes are used interchangeably. But it's getting rid of using the word disseminate and just establishing a rule, which is that the non-personally identifying part of the accident report is not confidential, just so it's clear for the public. Do you have follow-up questions?
No, not necessarily. I'm just trying to, I was just reading the concern about potential implications.
And, and again, if we feel like we need more robust treatment of that, of section 8, we can always take it out and ask the Right to Know Committee to do a little further work or take it up separately in legislation at another time. Other questions, committee members? I called for anybody in the room who wished to speak with regard to LD 2219, and I neglected to see if there was anybody online who wished to provide testimony. Is there anyone online who wishes to provide testimony? Okay, no one, we have no one online. And so all testimony having been taken on LD 2210, I'm going to close the public hearing. And then committee members, I would wonder if somebody wished to move to open up a work session. Representative Kuhn,
I'll move to open up a work session.
is there a second? Second by Representative Henderson. So we're suspending the rules and opening up. Oh, but we have to vote on that. Excuse me. All those in favor of moving into work session on this legislation, please raise your hands. That is unanimous of those present. And so just give Eli a moment to move things around.
Do we, because we're going to do a work session right after that, do we want to take a couple minutes and shift the room, or do you want to do this quickly and then shift?
Let's shift the room right
Okay.
now. Thank you. That was a good suggestion.
well-oiled machine. Eli Murphy, Office of Policy and Legal Analysis. So much of what you've heard with this brief public hearing, I won't repeat. I did speak to my colleague who is one of the staff of the Right to Know Advisory Committee, who did indicate that there wasn't really any discussion to the contrary of what is being requested by the Maine State Police with regards to Section 8. While that is true, that also means that there wasn't really any conversation about that change. So I don't really have any additional insight into that other than what Ms. Graham brought to you today and the discussion with Senator Carney. Yeah, this is, I guess, the only other thing that I will say is to keep you in this brain that we've been in recently is this is kind of like the Right to Know Committee's errors bill. It's intended to do these fixes versus big substantive changes.
Thank you, Eli. Questions for Eli? Representative Caruso, did you have one?
You know me so well, you can read my mind.
Your hand was in motion.
Yeah. I guess I'm just processing, just back to this issue on Section 8. Is there a way, and maybe this is a question for the department or someone on the committee, but it says the removal could narrow agency discretion in the future. While it does not create an affirmative obligation to provide the data, eliminating may reduce the agency's flexibility. And so I was just curious, could you ever say no to a request?
I think by my reading of what the printed language is in Section 8, it's a soft no. I think under the law, no, you couldn't for this information, specifically the non-personal identifying information, because it's not confidential. And so I can imagine there'd be a situation where someone is asking for all this data and, you know, the department says no for whatever reason that may be. There still would be the FOA avenue. And so then someone could FOA that information, and whatever is allowable by our FOA laws, they'd still be able to access. When given it being not confidential, I'd imagine that, you know, any of that information that does fall within this paragraph C that has been deemed not confidential would, whoever was requesting it would have access to, unless for some other reason that's not contained in this, it was barred.
Mm-hmm.
And so I don't think that changing from the may to not having that permissive may in here changes anything. And I think as Ms. Graham stated, it doesn't change the practice now. I think that the concern, and it might even be a soft C concern, is in a situation in the future that we can't really conceptualize now, there may be a change that would make it a concern.
Mm-hmm.
To my understanding, that concern is not realized at this point. And so I guess to get back to that first question, I don't think that there's any way under this specifically that someone could say no to giving out that information.
Mm-hmm. Could we have some just clarification from Ms. Graham?
Yes, Ms. Graham, could you join Eli? And I'll look to you, Representative, to ask her the question.
Good to see you again.
Good to see you again.
So based on your testimony, it was a concern enough that you included it in there, and you were discussing, you know, previously that commercial requesters sometimes receive bulk data extracts. And your operational realities that you mentioned. So could you just discuss this a little bit?
Sure. Just to Rebecca Graham, Director of Policy. Just to give you some background is once the main crash reporting system was created, There wasn't envisioned the extraction of mass data or the requests, but then we started getting flooded with them. So in order to develop a process that would allow things that make sense, like the location of accidents, high accident locations, the vehicles that are involved or may have some sort of nexus to that, but not the individual information. That seems like that is what the majority of the bulk requests are about. They're about vehicles and rental companies that want to know that back end stuff. What was happening is we were getting injury lawyers that wanted all of those. And because it is a public record for all intents and purposes in that accident report, that it became very clear that that was not the intent. So we were looking for a way that we could narrow that with a vendor that wasn't established yet. So the may in there allowed us to establish that relationship and provide a way to extract just those non-personally identifiable pieces that were of value and could be used in a way to advance public interest, but prevent the dissemination of the other items. The change from disseminate to disclose is not a problem. Like disclose is much clearer in Black's Law dictionary than disseminate is. So that's not a problem at all. It was just the ability for the department to establish that database. I don't think we'll pivot away from it, but should we, if that may disseminate or may disclose was removed from there, we wouldn't have the option. All of that would have to come out in that way. And it could be done on an individual basis, or we could be hit with those bulk and may not have the ability to say, okay, hold up, we got to wait until we get a new vendor. And we would still have to be forced to release that material. So it would be a capacity issue I can foresee easily in the future, but not necessarily anything that is going to change what exists now.
Representative O'Halloran?
So are defense attorneys now able to get the information that they need? Okay, thanks.
Yes, the individual reports are still available to them and do contain that data, but there's a clear need for that. And the fee on the individual reports is too much for someone to then go pull the last 500 accidents at $10 a whack in order to get that information. So it makes it very unattractive.
Any other questions, committee members? Yes, Representative Henderson.
Thank you, Madam Chair. It's good to see you this afternoon. Thank you for bringing this before us. It's been my belief and still maintain the belief that the majority, or if not all, of the changes in here are just non-material. This seems to be like it may at some point be material, but it is not fully formed into a material issue yet. So I would presume that if your system's changed, if there was an issue in the future, that there would be a comfort level to come back to the legislature to ask us to change this in a way that would better suit the needs, correct?
Yes, I think that's probably an onerous process and we might have to wait 6 months with a ton of those requests were that to be that reality, but we can certainly come back to the legislature in future if that does change.
Do you have any, so you've outlined something that could potentially be a problem in the future for Section 8. Do you have a proposal, a way that we could change it? Or are you indicating that you'd like us to just switch it back to the way it was before? Or is there a new language that you'd like us to consider?
I think that's the policy question. I think from our point of view, the construction was such that it allowed us to optionally provide that service and not require it. I think the removal may require us to do that in the future, which we would do on a regular basis. We're unlikely to change that practice, but if for some reason that system was not available and it then pushed back onto staff to do instead of a technical change in the background, that may be the beauty of the word may in there. But the rest of that change, I totally understand and think that that's appropriate. And you may just change it to disclose, I guess. That may be just the fix, but I think that's the policy question for you. I just think it's important for you to have the history as to why the may was there and why that might be important in the future.
I have another question. Hope that I can articulate it clearly. So the way I read section 8, without any changes as proposed in the bill, but that portion of the statute, it's talking about, it says may publicly disseminate non-personally identifying accident report data. To me, what that's saying is that if it is non-personally identifying, then it is non-confidential. And so if it is non-confidential under the law, what would be the basis for withholding it from somebody? That's what I'm trying to see, like, is there an underlying right to say no when somebody requests outside of the scope of the BOA process for requesting information? Because I don't think there is, and my concern would be that if we continue with the language that implies that there is a way to withhold non-confidential information, I just don't feel like that's true to our public access laws. I'm wondering if you have a reaction to that, or if there is some provision somewhere that does make this non-personally identifying information confidential, such that it could be withheld.
I think it really focuses on operationality, and we had a stakeholder group with IF&W in the interim, and they have accidents that involve vehicles that would go into the crash reporting, but then they have accidents with snowmobiles and boats that do not, and they've been inundated in a way that was overwhelming for them for that data. So we're trying to get them actually into the crash reporting system so that it can handle those bulk requests. So it's really an operational question. There's a withholding question there, I think, for us. The way that we approach all FOA requests is that personally identifiable information is confidential. So they would never receive anything but the non-confidential. And it was just the bulk piece that enabled the bulk piece to occur. It didn't require it to occur because we had to have those other pieces in place, like the relationship with InfoMe and the access to the back end of that. So I think operationally, IF&W has learned that it's a challenge to operate outside a place with that in place and provide all of that data to all the requesters when they're not in a system that allows that back end, because they're also getting the same requests.
And so are they being integrated into the system that you're using?
I think there was a bill that may have been heard in IF&W that would change some of their statutes in Title 12 to mirror what Title 29 it does for us with that bulk data as well.
Thank you.
So you may see that as on a review, I bet.
Okay, thank you very much. Other questions, committee members? Representative Sinclair?
Thank you, Madam Chair. This is not a question, or may not, I don't think it's a question for Ms. Graham. I'm trying to find some proponent of the bill who could answer a question as to why we in Section 8 are taking the pains to name data that are not confidential. I mean, that's our default. We typically specify when something is confidential. And if we haven't specified that it is confidential, none of it's confident. Why are we taking the pains to call this out specifically as non-confidential? What do we get from that?
I can't answer that question right now. Maybe Eli can, but so 29A, 2251, 7A, C has always dealt with the ability to disseminate non-personally identifying information. It used the word may to indicate that it's discretionary when it probably isn't. And so I don't know. I mean, I do think that it is helpful in explaining why the Department of Public Safety would refuse to provide the names and addresses and phone numbers of people involved in accidents. And so I think sometimes it's helpful in that way, but it's not. Yeah, so that's, I guess, the best I could do, but maybe Eli can help us out more.
So Title 29A, Section 2251 is accident reports at large. And so it covers everything contained in those accident reports, reports required, et cetera, et cetera. The subsection 7A, which is contemplated by this section 8 of the bill, is the accident report database, public dissemination of accident report data. And so it covers everything contained in that, both confidential data as well as non-confidential data. This paragraph C, it is, and so accident report database, public dissemination of accident report data, data contained in an accident report database maintained, administered or contributed by the Department of Public Safety, Bureau of State Police, must be treated as follows. And so it covers all of that data and how it is treated. Paragraph A is definitions. Paragraph B, except as provided in paragraph B1 and Title 16, et cetera. The state police may not publicly disseminate personally identified accident data reports. Paragraph B1 may disseminate a vehicle registration plate number only if that person provides an affidavit stating that the person will not use it in certain ways. And then paragraph C covers the non-personal identifying accident report data. And then there are paragraphs or subparagraphs about violations, prima facie evidence, et cetera.
Thank you. Does that help, Representative?
It renews the question for me, but that may be fog of brain.
Okay, thank you. Representative Henderson.
Thank you, Madam Chair. And I think in somewhat of a response to Representative Sinclair's question, is the intent for the Right to Know Advisory Committee to take this up was for the, was it that Janet used statutory beautification project? And it was just to take language that is obsolete and renew it with language that is consistent throughout statutes that reflect the right to know's jurisdiction. So as much as I want to like dig into the underlying policy, I think it was a policy decision of the legislature at the time to identify it from this perspective. And what our job at the right to know is, and maybe what this bill does, is not to look at the underlying policy as much as to make sure that during the statutory beautification project, we didn't materially change the underlying policy itself. So I don't think I personally don't need the answer to that question, because I think it starts to deal with the intent behind the policy rather than whether or not these changes make material changes.
Thank you, Representative. And again, I question the validity of having non-confidential information that could, with discretion, not be disclosed. I just don't think that that's what our right to know laws are all about. So committee members, I think we have a couple of different paths forward. One would be to table this and not vote. The other would be to vote on it with one amendment, changing the word evidence to criminal procedure. A third path would be to have a motion to amend that would change evidence to criminal procedure, but would just take out section 8 and save it for another time if people still have questions about section 8. So what is the pleasure of the committee? And thank you. Yes, Representative Sato.
Thank you, Madam Chair. I would be comfortable voting today with just the one amendment in section 1.
Would you like to make a motion?
So moved.
Is there a second? By Representative Sinclair and a whole bunch of other people. Oh, before we move on, I thank you, Co-Chair, for putting this out. We have been joined by someone from the Office of Cannabis Policy. They wished to weigh in on one section of this, and they missed the public hearing section, so I would like to recognize them. They're available on Zoom in the work session, and so we'll keep the work session open. We won't move on to a vote on the motion until we hear from them. And thank you for the reminder, Representative.
Good afternoon. Thank you so much. I am Gabrielle Barabee Pierce. I'm the Policy Director for the Office of Cannabis Policy. And I just wanted to make myself available in case you had questions about the one provision of Title 28B, the adult use cannabis statute, that is addressed in Section 3 of the bill. It is an exception to an exception to the FOA law. And so for our office, we definitely have concerns about administering, but I'm happy to answer any questions the committee might have. I apologize for not submitting testimony. I was going to get to that later today.
Questions? Oh, can you please stay on? Yes, thank you.
Yeah, sorry about that.
Questions, committee members? Representative Sinclair.
Whenever someone joins us and uses the word concerns, my ears prick up a little bit. I wanted to just make sure you had opportunity to voice those concerns if you chose to do so.
Thank you. I appreciate that opportunity. The way Section 3 is written would basically make public information. So it's similar to, you know, question that was asked earlier during this, and I'm sorry, I'm trying to pull up the language. So we have a confidentiality provision that covers personal contact information, except if, so the bill would change that to make that information public if the home address, telephone number, or email address has been provided as public contact information. Would make that non-confidential information. And we just don't know what is meant by the term public contact information in this context. And because that section of the statute deals with confidential information. So, and then administratively, we would have concerns about accidental disclosure of information intended to be confidential or not confidential, unless we can kind of really put some guardrails around what is meant by public information in that section.
Other questions, committee members? Representative Henderson, were you on this subcommittee? No. I will just, and it seems to me, and I was not on the subcommittee either, but I think what they're saying is if the applicant, employee, or other persons have publicly listed, for example, their name and email address and home address and telephone number on a website for the business, for example, then that it wouldn't be considered, because they had made it public, it wouldn't be considered confidential because it was indeed publicly available. That's my best understanding of it. And I know that we've had some debates about this in prior sessions about the availability of public contact information.
Okay.
Eli's going to see if he has some insight for us.
I also have our survey for the Right to Know Advisory Committee for that particular provision, if you have any questions about our responses. We had recommended no changes to that section because it has been working pretty well, and we make available on our website all publicly available, or sorry, information about our registrants and licensees that is currently publicly available. So the name, your name might be associated with a license online, but your personal contact information would not be available online on our website.
Representative Poirier?
Thank you, Madam Chair, and thank you for joining us. Could you give me kind of like a scenario where if this were to be put in place where it might be problematic?
Yes. So we regularly get requests, and we noted this in our response to the advisory committee as well. We regularly get commercial requests for personal contact information, licensee and registrant contact information for marketing purposes from a variety of different businesses. And so being able to distinguish between what is somebody's business phone number versus what is somebody's personal cell phone number or personal email address versus business email address would be harder here because we have to collect information as the licensing entity in order to be able to contact our licensees, right? And what we noted in our response to the survey was it is important for us to be able to get in touch with our licensees at all times, and they provide us the best contact information they can for that business. We would be concerned that we would provide accidentally information intended to be confidential or withhold information intended to be public just because there's really no way that we as an agency would necessarily know that, oh, you've posted your business on Weed Maps within the last 5 weeks or what have you. We wouldn't necessarily know that's public information. And being able to kind of, if it is some sort of external trigger that would indicate something is public information, that's kind of a variable state, I would say, for that information over time too. So just from an administrative perspective, clearly understanding what is meant by that public information, possibly defining it in statute, putting some guardrails around that would be helpful.
Thank you so much.
Any other questions, committee members? I'm going to suggest that I do think that there's not even any time constraints on the providing information as public contact information as well as to whom it gets provided. And so I feel like section 3, unlike section 8, section 3 does have an operational impact. And my concern would be that it needs more time and energy to address it. So that would be my opinion as a member of the Right to Know Advisory Committee. Representative Sato.
I would agree with that, especially because the purpose of this legislation is to be technical and not substantive. So I would amend my motion to also strike section 3.
For the seconder, Representative Sinclair.
I embrace that amendment of the amendment.
And committee members, any discussion? Anybody feel the need for a caucus? Yay or nay?
Yes.
Yes, okay, thank you. Okay, let's take a 5-minute caucus and we'll be back shortly before 2:20, everyone. We're back from our brief caucus break and we're in the middle of a work session on 2219. This is the Right to Know Advisory Committee bill. Is there any further discussion, committee members, before we move on to a vote on the ought to pass as amended motion? Not seeing any discussion. Eli, could you call the roll, please?
Sure, let me get a form of it. The motion is ought to pass as amended by Representative Sato, seconded by Representative Sinclair. Senator Carney.
Yes.
Senator Carney votes yes. Representative Kuhn.
Yes.
Representative Kuhn votes yes. Senator Hagan. Representative Poirier. Representative Sinclair.
Yes.
Representative Sinclair votes yes. Representative Pugh.
Yes.
Representative Pugh votes yes. Representative Henderson.
Yes.
Representative Henderson votes yes. Representative O'Halloran.
Yes.
Representative O'Halloran votes yes. Senator Talbot Ross.
Yes.
Senator Talbot Ross votes yes. Representative Lee.
Yes.
Representative Lee votes yes. Representative Sato.
Yes.
Representative Sato votes yes. Representative Babin.
Yes.
Representative Babin votes yes. Representative Crusoe.
Yes.
Representative Crusoe votes yes. I will recall the absentees. Senator Hagan. Senator Hagan is absent. Representative Poirier. Representative Poirier is absent. And Representative Dana. Representative Dana is absent. 11 votes yes, none votes no. That is the vote of the committee.
Thank you. And so the ought to pass as amended motion carries unanimously of those present. And thank you, committee members. That speeds us on our way to meeting our deadline to vote bills. So we'll close the work session on that one. And now we're going to begin another work session, which is a work session on LD 2168. This is an act to increase accountability for persons engaged in commercial sexual exploitation and human trafficking and to support victims. And there has been a proposed amendment. I don't see the sponsor here. I don't know whether she'll be joining us. Oh, she's an AFA. And we expect the sponsor to be joining us momentarily, and she does have an amendment that she would like us to consider. So I think we'll get started in just a moment.
Good afternoon, committee members. As Senator Carney said, there is a proposed amendment that will be coming from the sponsor. I do have some information prior to that I will go over. I will note, as you see on this bill analysis, it was dated February 12th, 2026. We had originally scheduled a work session. I prepared this information for that point. Obviously, there has been some work done in the meantime, which is why we held off on that work session. And so a lot of the information I have for you in this first blue packet is relevant to the discussion. However, there's more conversation, which is the second packet Supi is passing out. I foresee this to be kind of a fluid conversation with the information that I have, as well as the amendment by the sponsor that will be coming. So I guess to begin, LD 2168 is an act to increase accountability for persons engaged in commercial sexual exploitation and human trafficking, and excuse me, and to support victims. This bill would direct the court to impose a $500 assessment or a $1,000 assessment for repeat offenders on a person convicted of engaging a person for prostitution, sex trafficking, aggravated sex trafficking, soliciting a child for commercial sexual exploitation or commercial commercial sexual exploitation of a minor or a person with a mental disability. Money from assessments is deposited into the victims' compensation fund and must be used to meet the needs of victims and survivors of these crimes. So some background on this area of law, and some of you may remember as members of this committee, in 2025, last year, this committee passed LD 1877, which was enacted. A copy of that law is attached. And what that law did is it increased the mandatory fees paid into the Victims' Compensation Fund for 4 of the 5 crimes contained in the bill as printed, with the exception of commercial sexual exploitation. This law does not direct specific use for those funds in the way that the current bill does. However, I will say, and you can see in it is the first of those white attachments to the blue packet. It does increase some of those penalties significantly further than what the bill as printed does. And so in by that is that this committee has already raised those mandatory fees. This bill, as it's currently printed, would be a duplicative effort. In addition to that, attached is the section of law that covers the Victims' Compensation Fund. That should be VCF, not VFC. Relevant to the discussions of this bill, including the section for funding sources and the section on awards and compensations. And so I've given you the full text just to show you kind of the full scope of what we're talking about. There are a number of different funds. All right, so let me get through the full blue and then I'll talk about that. In Clack's testimony, they suggested that in addition to, two things. They suggested they had concerns with providing a waiver for the additional assessments, which is not currently in law. Any of the additional fees or assessments, whether it's the Victims' Compensation Fund or there are a couple of other ones that I will discuss, none of those have the option for those to be waived. Those are mandatory fees. Some of you may know that other fees or fines imposed by the court, there are the ability for those to be waived. That is not true for these specific additional fees. And then the additional ask by Clack was to make sure that any additional fees that are asked for or required to be included in the complete list of surcharges and assessments imposed by imposed on convictions that are outside of the criminal code. And so the last page of this first blue packet you have is section 1757 of Title 17A, where there is a list of other fees. And so one of the things that I did not include in your packets, but I do have the information that I wrote down, is what those actual fees are. And so on that section 1757, the first one, the surcharges for government operations surcharge fund, there is both a 14% fee surcharge, rather, a 14% surcharge on any fines or assessments ordered by the court. There's an additional 5%. There's 2 different funding destinations, and so there's 2 different surcharges under that first one. So a 14% surcharge and a 5% surcharge. Obviously, we are discussing the assessment for the Victims' Compensation Fund, and so that's variable. And we can talk about those numbers in a few. The third one, the surcharge for County Jail Operations Fund, that is a 1% surcharge on any fees, assessments, etc. And then if you go down to that subsection 2 on that page, a surcharge, this gets to surcharges for specific types of crimes, which is more akin to what we're talking about here. For any crime or any conviction, rather, under 17 chapter 42, and that is the animal welfare laws. There is a 10% surcharge added to any fine or assessment. And then finally, with respect to OUIs, there is a $30 additional mandatory assessment for any OUI, or if the alleged facts are an OUI where the intoxicants are drugs or a combination of alcohol and drugs, that mandatory assessment is $125. So that is just a scope of other mandatory assessments that are required of various convictions beyond the specifically named ones. Or I guess I should say, within the Victims' Compensation Fund, any Class D or E conviction has a mandatory assessment of $35. Yes? 45. 45 now. My apologies. It's been a few years since I've worked in the criminal branch, or the judicial branch rather. And then for the Class A, B, and C, it is a $70, which has remained $70. Yeah. With the exception, of course, of these specific crimes that we're discussing today, which are the sex crimes that have much higher mandatory assessments. And so I think that gets us to the amendment. I think.
Committee members, any questions before we move on to the proposed amendment? Representative Sinclair.
Thank you, Madam Chair. Eli, I just want to make sure that my file is complete as of this date. Have we received anything written from CLAC more recent than their February 2nd note to us opposing the bill?
I have not received anything, no.
Thank you.
Any other questions, committee members? Okay, let's move on then to unless Representative O'Halloran, did you want to ask a question before we move on to the amendment? Okay. All right. And so let's have the sponsor come up and just speak briefly to the amendment, and then Eli, if you could walk us through it in relation to the original bill, that would be helpful. Thank you.
Thank you.
Welcome.
Thank you. And I may defer to both Alicia and Nate to come and discuss this, but we can start with me.
Okay.
Because they've done the amendment. They pulled together a lot of the language, so.
Okay, would you like to introduce yourself?
I would. Thank you, Madam Chair. My name is Holly Stover. I'm the House Representative for House District 48, including Booth Bay Harbor, Southport, Edgecombe, Westport Island, and South Bristol.
Thank you.
Thank you for having me back.
You're welcome back. Would you like to just briefly state the amendment, and then I think Eli could take it from there?
In front of me. I'm actually going to have Alicia, if I could have Alicia come up.
That's fine. That's fine.
I mean,
Thank you for-
the one thing you just mentioned towards the end is that one of the parts in the 2023 and the 2025 that was, I want to say left out, I don't have another phrase for it, was that sitting on the table still is we have a fine that would be amended for the purchase of commercial sex trafficking involving children, minor children, was left behind at $70. So for a first offense, so you raised the rates in 23 and 25, but what didn't get put in there was the rate of a fine on a commercial sex trafficking charge on a child, which seems almost counterintuitive to everything you tried to do with the other lifts on those fines. And I don't think any of us could ever understand how we left children behind on this one. So I would ask Alicia to come up maybe and
thank you.
Walk through the rest of the amendment, but that's the one piece that I really want to hold up.
Yeah, thank you for pointing that
$70
out.
fine on a conviction of a child.
Thank you. And I think there was a question for you before you get up. Yes, Representative Sinclair.
Madam Chair, I've heard a lot of references to quote the amendment, but I don't have one and my neighbor doesn't either.
That is because there isn't one. Eli is going to talk us through what the proposed amendment would be with relation to the language in the bill before us, so that we can kind of compare it to this, but there isn't a fully drafted amendment yet at this time. that we're ready to
Language
distribute.
to present.
Okay. So let's do this. Thank you, Representative
Thank you.
Stover.
Thank you. I'll be
Alicia Melnick is going to join us and I don't know if did you bring copies of the amendment by any chance?
I didn't, I don't have anything drafted, but I'm happy to do so. I think it's
No, I think, I don't think one is needed because I think that we
pretty
can,
straightforward.
it's pretty
Yeah.
straightforward. And so, committee members, I would just ask you to look at the original bill. And then, if you could introduce yourself and then just describe the amendment.
My name is Alicia Melnick. I'm an attorney at Bernstein Scher, and I work on these issues on behalf of World Without Exploitation and National Center on Sexual Exploitation. As Eli mentioned and Representative Stover mentioned, in 2023 and in 2025, several of these crimes the assessments were increased, but the assessment on solicitation of a minor or a person with a disability was not changed. So that remains at $70, while the others were bumped up. Sex trafficking, aggravated sex trafficking, commercial sexual exploitation of a minor or a person with a disability, and engaging a person for prostitution were all increased in either 2023 or 2025. The amendment would also bump up the solicitation of a minor or a person with a disability, so that it also had an additional assessment in line with the other sort of similar crimes. So the proposal would be that for solicitation of a minor, it would be 1,000 for the first offense and 2,000 for each subsequent conviction, which brings it in line with what is currently in place for engaging a person for prostitution.
And Senator Carney, I'm going to just orient the committee. So one thing that I failed to mention is that this language we're talking about, it's not in the bill printed. What you're going to be looking at, just for your reference, is in that blue packet. These changes are going to be to the section of law that was changed in Public Law 25, Chapter 387, which was LD 1877 in 2025. And so that is the text we're talking about.
Thank you.
Not the bill as drafted, because that was different language.
Okay, thank you for that clarification. Okay, so reorienting us to the first white page in the blue bill analysis.
This is the section of law.
And so,
Eli, do you
Yes.
want to walk us
yeah,
through it?
sure.
Yeah, that would be great.
So what we have in front of you, if you're looking at that, what was LD 1877, is you have a list of crimes that a conviction creates an additional assessment. And so the language used when it's repeated is, let me find, an assessment of X number of dollars on any person for the first conviction and X number of dollars for each subsequent conviction. And so what the amendment would be doing is adding to that list of assessments language to the effect of an assessment of $1,000 on any person for the first conviction and $2,000 for each subsequent conviction of, and then naming the crime, soliciting a child for commercial sexual exploitation as described in Title 17A, Section 259-B. And that would, just for the sake of the way that we order things, it would go right after the 17A 85 or 853B. So it would be, oh no, my apologies. It would go after, 17A Section 855. And so it would go 1, 2, 3, 4, 5, 6, 7 lines up at the kind of end of that line. It says Title 17A Section 855. There would be an or and then the language that I just stated.
1,000 for the first.
Correct.
And then
2004 in any subsequent. And then we can pause there, and there's one other change that I'll explain after.
Okay, can you just explain the other change and then we'll start with questions just because sometimes it's easier to do it that way.
Sure. The other change would be increasing the increasing the one that I mentioned, the 17A 855. That would be increasing what currently in that law you will see says an assessment of $1,000 on any person for the first conviction and $2,000 for each subsequent conviction of commercial sexual exploitation of a minor or commercial sexual exploitation of a person with a mental disability as described in Title 17A, Section 855. Those numbers, that 1,000 and 2,000, would be elevated to 3,000 for the first and 6,000 for any subsequent, which is mirroring the change that was made in that's LD 1877, where you see those changes are elevated for sex trafficking in Title 17A 852, which you see at the beginning of that block paragraph you have in front of you.
And then is there any other element to the amendment? And then we'll start with committee questions.
The second element, I'll let you go over because that one I haven't covered yet.
So currently, as you all have in 2023 and 2025 increased some of these assessments and they go into the Victims' Compensation Fund, there are some requirements to be able to access that fund for victims. And one of those requirements is that there are some sort of prohibiting offenses that preclude someone from accessing those funds if someone has some offenses. So this would allow a person who was a victim of sex trafficking or sexual exploitation for whom the violation of that law would be a barrier to them accessing that fund. It would allow the board to have discretion to waive that prohibition if those offenses were related to them being trafficked or exploited. So this is essentially in line with the way that you all expanded access to sealing of records. We all know that people who are exploited or trafficked there's often a forced criminality aspect to that coercion, and they may have convictions on their record for things that they really were not able to. That was an inherent part of their exploitation or trafficking. So this would just allow the board to waive that barrier in accessing these funds. There is already an exception where the board may waive the time requirements. There's a requirement that they have to report the crime within, I think, 5 days. So the board already has some discretion to waive those requirements because we know that there are many circumstances where somebody might not be able to abide by that timeline, but they might warrant consideration for this fund. So
Can you direct us to where, is this part of the white attachment to the bill analysis where those waivers are? Just so that we can.
The amended language, if you look in the blue packet where I gave you the full chapter of this kind of section, it is, I believe, 3360-C. Which is requirements and exclusions.
Right.
And so that is on page 4 of the numbering starts in the middle of the packet, but if you look for the one with the page 4, it's at the top of that page.
Yep. So right at the top, you see requirements and exclusions. Compensation may not be paid for any crime unless it was reported to law enforcement within 5 days. And then so that they already have discretion to waive that time requirement, and this would allow them to waive 2B. So a person who has violated a criminal law that has caused or contributed to the injury or death for which compensation is sought, except when the person was the victim of a criminal homicide and the claimant was not involved in the criminal conduct. It would add to that that if someone was a victim of sex trafficking or sexual exploitation, and the violation of criminal law was the substantial result of that sex trafficking or sexual exploitation. Again, it's quite mirroring the considerations related to sealing that you all considered last session.
Okay,
or last.
Thank you. Eli?
And so what SUPI is passing out, this is not in the form of a polished amendment. So I'm just going to kind of briefly orient you to what you're seeing. This first section, the proposed amendment, section 1, that is the first bit that you are, we were talking about where to put those additional assessments in that page that you saw in the blue packet. And then what we are now talking about is
So
kind of
I'm sorry to interrupt you, Eli, but so that would actually be this amendment that is to chapter 387?
correct.
Okay.
Yes.
Thank you.
The proposed amendment, section 2, that is what Alicia is currently discussing. And so we are now, I've oriented you to where that amendment would be in that same packet that you were just looking at the page 4.
Great. Thank you. Okay. Anything else? All right, let's open up for committee questions. I know Senator Talbot Ross has one.
Yes,
Go
thank you,
ahead,
Madam Chair.
Senator.
Thank you, Madam Chair. Thank you, Alicia, and Eli. Thank you, Representative Stover. It just feels to me like all we're doing is we're making sure that we have parity. And so in Title 17A, Section 852, and then again in Title 17A, Section 855, we're making sure that the solicitation is on par with the current law. And the increase in fines to $3,000, $6,000 are also on par with what's in current law. So these are related to the solicitation of a child for sexual exploitation and persons with mental disabilities. So this is just bringing, I mean, I'm just going to cut to the chase. So this is just bringing it all up to that same level as those other crimes that we were able to identify in 2023 and 2025. So that's one part of it. And then the second part of it.
Wait, let's let her
is that-
answer on the
is that
record.
right?
Yes, that's exactly right.
Thank you.
I think, right, if you look at sort of the stacking and the level of vulnerabilities in terms of who is being targeted by, by these crimes, it felt like there was a little bit of a gap in terms of what the goals were of the policies that you passed in 2023 and 2025. And this seeks to, yes, to align those in a logical way.
Yeah, and I would agree with the bill sponsor that I don't know how that got missed. But obviously soliciting a child for sexual exploitation or a person with a mental disability needed to be included. So I'm grateful that we're going to be able to, hopefully we'll be able to bring that to an equitable place in law. And then the second section really does, as you said, it does mirror what we did with forced coercion in the sealing of records when it can be traced back to that coercion. So the forced criminality of it. And so it feels right. Like this is a good piece of legislation that we can bring forth. And I just wanted to make sure I was keeping up because there's so many moving parts right here.
Yes.
But I do appreciate the work that's gone into this and I follow along with the first step and then the second step. And thank you again for bringing this forward.
I appreciate your all's patience. I know it was a little hard to digest in the moment.
Yeah, it's also that point in the legislative
Yes,
session
sure.
where there's paper flying everywhere. I just want to echo the senator's sentiments. I do feel that this is establishing important parity. And I also am really pleased that Representative Stover, that you're continuing the work that Representative Reckett had led this committee on, and I'm really grateful to that. Any other questions, comments? Yes, Representative Henderson?
Thank you, Madam Chair. So totally agree with Senator Talbot Ross about seeing how we're trying to create parity. But in the way I understand how the law is written on crimes against children is oftentimes crime against an adult might have an elevated charge if the same crime is committed against a child. Was there consideration in your discussion on this in bumping it up from 1,000 for the first offense and 2,000 for subsequent offenses to a higher number?
I think that is something that the committee, I don't think there would be resistance to that from the sponsor or the people who were helped work on this bill. We were, I think, just trying to align it with the will of the
legislature's changes thus far. But, you know, I hear what you're saying. I think the targeting of minors and people with disability is something that again, this is a population that's even more vulnerable. But in terms of the level of crime versus the assessment, I don't know I know Nate Walsh, who works a lot on these issues, is here in the room as well, and he might have a better answer to that. But again, I think if you all had a desire to increase the assessment even more, than the 3,000 and 6,000 for actual trafficking or exploitation of a minor and 1,000 and 2,000 for solicitation of, I don't think there would be opposition to that. Thank you.
I think the sponsor would like to address us. And then Representative O'Halloran, you can go with your question.
Thank you. Thank you, Madam Chair, and thank you, Representative Henderson. We did talk about this and really wanted to bring it back to the will of the committee. I think that aligning it was our first purpose, but the second purpose certainly could be, because I think we all know and understand that children or minors, we call them minors, but they are children, and people with disabilities are targets for people who participate in commercial sex trafficking. Because there's several reasons. One is they're more vulnerable. They're also they're more difficult as witness. They're not difficult, but it's harder as witnesses for these two particular populations to be able to carefully and creatively describe what happened to them. They're far more vulnerable and targeted more often. And I certainly, the committee, it was the will of this committee to look at those penalties and raising them higher because of the particular special populations that we're talking about, minor children and people living with disabilities. And I would certainly support that because of the nature of it and the nature of the crime, because you're not just targeting, but you're preying on particularly vulnerable populations.
Thank you.
Thank you.
Representative O'Halloran, was your question for Alicia Melnick, for the bill sponsor, for Eli, or for someone else?
It might be Eli.
Okay, go ahead.
Sitting on the Penobscot County Budget Committee, I'm wondering, are these, and I'm all for raising the fines, but are these fines that would have to be paid in order to be released? Or is it something that the state could take from their tax returns and things like that if they were, like after they've served their sentence, if they don't have the money to pay the fine, are we going to keep them in jail till they pay it? Or would it be something that the state could?
These would be separate from any ordered period of incarceration. They're different than fines, but they are kind of all assessed together and then distributed as such. The judicial branch may have more insight into the actual functions of that. They wouldn't necessarily keep someone in jail other than there is situations where, and it is certainly possible for the court to order someone to serve a period of time for failure to pay fines. In my understanding, that is more rare than not, and also occurs at it's not a keeping you in jail, it's more of after a significant period of time, serving a period of time. So I guess to in short answer your question, I don't know that this would keep someone in jail, but there may be ramifications down the line for not paying them.
Yeah, I think that that's an important issue to track down, like what happens with the assessments. And Representative Sinclair, I know that you have your hand up. Is it to answer Representative O'Halloran's question, or is it a separate question?
I raised my hand for a question for the sponsor.
Okay, have you asked the question of the sponsor, and then let's ask either the ADA or a representative from the judicial branch to give us some more information about the assessments. You may proceed with your question.
Thank you. Representative, I don't remember whether you were with us for the public hearing. If you were, you may remember, and if you weren't, I'm sure you reviewed the proceedings afterward.
you're likely aware that we received testimony against the bill from both CLAC and from Swirl, the Sex Workers Collective. Have you done any additional work since then to try to address the various concerns that those two stakeholders brought forward?
I have not, and I would defer to either Nate Walsh, who's had opportunity, or Alicia. I have not personally.
Representative, did you wish to ask the questions of Alicia Melnick? Yes.
I'm happy at any point in today's hearing to hear the answer from whoever may hold an answer that's different than the sponsors.
Okay, thank you. Okay, so let's go back to the question raised by Representative O'Halloran, which has to do with the assessments. Is there anybody in the committee room who could help us understand what happens with assessments when they're leveled and the person who is assessed is unable to pay them? Are you able to join us, Attorney Walsh? Thank you.
Thank you, Senator. So my name is Nate Walsh. I'm a human trafficking prosecutor in Prosecutorial District 3. I've been serving that capacity for the last decade. Prior to that, I served in Cumberland County as a human trafficking prosecutor briefly. So I've been working in this issue for a while. I've also been in ADA handling. I've handled pretty much everything except for homicides at this point. So I can say generally that when someone is convicted of a crime, they're sentenced, and if the sentence includes a fine, they're subject to fees and surcharges. The rough math is usually about 20% plus the victim compensation fund assessment. If it's a jail sentence, they're still without a fine assessment. They're still having that victim compensation fund assessment imposed. And it depends on the classification of crime as to what that victim's comp fund assessment is. And that is money they owe the state. So generally that goes onto their general obligation to the state imposed by the court. So I don't believe I've heard it been an impediment to their release from incarceration if they are incarcerated, but it would be still a financial obligation that they owe to the state. And typically what I've seen happen is that if a person has non-payment of their financial obligations to the court, they're given notice of hearing and after an opportunity for notice and hearing. If the court finds that they have either failed to appear for their hearing as to why they haven't paid their obligation to the state, or the court finds that there's been a willing, intentional disregard for their sentence of paying that assessment or that fine, then the court is able to have that person serve a sentence for that or to be incarcerated. Typically, what we see happen is someone shows up for their fine, non-payment of fines, either as a result of a failure to appear warrant, where they're arrested on that warrant, brought in. The court has the ability to waive, I believe, some of that financial obligation to compensate for however long they were incarcerated waiting to be seen. And then work out a payment plan with the state in accordance with their financial obligation. So I've seen sometimes the court set $10 a month for people who are indigent, starting whenever they feel as though that they can start making payments toward their fine obligation. The victim compensation fund assessment cannot be waived. So if this is assessed to someone who's been convicted of one of the crimes, generally these higher enhanced ones we're seeing are all Chapter 35 offense violations that are sex trafficking, prostitution, and public indecency. So those would have to be paid and they can't be waived by the state, any of those enhanced obligations. So yes, there is a chance that someone could be incarcerated for not payment, but typically it involves either not showing up for court after being given an opportunity for notice and hearing, or the court finding that they've willingly not paid their fine.
Thank you, Representative O'Halloran. We're going to ask you some more questions, I think.
I know with sometimes when people are owed like tax returns and stuff, even when they owe fines or fees to the state, they'll just take them and that will pay it. Would that happen with this process?
I'm not familiar enough with the judiciary, how they satisfy their obligations, but I have seen where, like, let's say someone posts bail, they won't get that bail money back if they owe money to the state in terms of obligations. So I do believe there are mechanisms for the state to collect to obligations that I think, I'm pretty sure I've seen where if there's bail money posted for someone, they run a check to see if any other financial obligations they owe the state, then the state can collect that money.
Other questions for ADA Walsh? Okay, I'm not seeing any. Thank you. Committee members, is there any other information we feel that we need? Any committee member like to initiate discussion? Representative Henderson?
Thank you, Madam Chair. I guess I would just ask kind of what the feel is for the committee on potentially increasing from 1,000 and 2,000 to a different number, a heightened number, what the comfort level for that would be. Personally, I'm struggling remaining objective in this respect. You know, seeing that a fine of $1,000 could be imposed on somebody purchased a child. And but I know that I'm lacking some objectivity right now, and I'd just like to hear from the rest of the committee.
Any other committee member wish to respond? Representative Lee?
I share your repulsion to that notion as well. I like the idea of maintaining parity just from a purely objective standpoint. And I would be hesitant, again, noting the repugnance of the crime, I would be hesitant to proliferate too much, too fast, because it just, where does it stop, right? All crime is repugnant. So are we just going to keep on boosting up these fines and have a whole bunch of unpaid fines as a consequence of that? So my preference would be to go with what has been suggested in keeping parity.
Senator Talbot Ross?
Thank you so much, Madam Chair. I agree with my colleagues. What I'm struggling with, Representative Henderson, is what is enough? I mean, how do you put value on that? I don't know. I don't know what is the magic amount of money. Then it is horrific. What I am putting my trust in is that the sponsor and those who've done this work are asking for that parity, and I want to give them that parity. I'm almost so nervous about those other crimes. Then we come back and then we would have to make sure that the parity existed across all of those other repugnant crimes as well. And I'm not sure that we have all of the information we need, that we could put an assessment on that. I don't know what that number is. I'd hate to say it's just another $1,000 or it's another $5,000 when really it's beyond our comprehension, really. So I'm with you, in my heart, in my spirit, but I think that the sponsor who works in this, spent her life. I'm going to trust that this is the best step forward right now, and try to get to parity and then continue to work on this in the next legislative session, if we're all lucky to come back and serve on this extraordinarily gifted committee. But I thank the sponsor for her work once again, and I hear you. I just would like to get at least this piece done.
Other comments? Representative Kuhn?
Thank you. I was just going to also add for Representative Henderson's consideration that this question of the financial penalty is really just one of the components that the committee deals with to address this conduct, because we talk about class of crime and sentencing and statute of limitations and all the different tools that are available to address that conduct. And this is just one component. And to me, getting to parity seems like a good adjustment for us to make at this time and see what impact that has.
Any other comments from committee members? I have just one quick comment, which is, for me, I think another really powerful part of this legislation is allowing the waiver of the prohibition for people who were victims of illegal trafficking, both to honor the work of Representative Stover and also the work of Representative Reckitt. I feel like these funds can be hard to access for people who need them through no fault of their own. And I really appreciate that element of this. I don't want that to get lost in the talking about the assessments, because I think the relief for people who are crime victims is equally important. Any committee yes, Representative Henderson.
Thank you, Madam Chair. I guess a question. In the original bill as drafted, it has a section or a sentence in there in lines 20 and 21 that says the court may waive all or part of the assessment under the section based on the convicted person's ability to pay. I'm not seeing that in the language in front of us, and I'm wanting to just ensure that where this language in front of us isn't a polished version, that ability to waive that is not included. Am I understanding the intent?
Alicia Melnick, would you like to just address that, please? I know that you've been working hard on the amendment.
Alicia Melnick, thank you for the question. That is correct. That is not in there. And actually, that is one of the things that was flagged by CLAC as a concern and sort of something that would be not within the normal practices. So yes, that is not part of this. And again, it would be in line with the other changes that you all made again in 2023 and 2025 are not subject to any ability to defer out of it based on an ability to pay. And I think again, this class of crimes where inherently someone is spending money to, purchase someone for sex, and in this case, a minor or a person with a disability. I think that consideration is even less warranted. So that is not included in here. That is correct.
Thank you. Any other questions? Thank you very much. Would any committee member wish to make a motion? Senator Talbot Ross.
Just thank you, Madam Chair, just to clarify, so we can move, even though we don't have the, all of the right language written in the right form.
Yeah, it will come back to us for language review, and
Yeah.
one of the benefits of having a vote today is that it keeps us on track to get this to the legislature, to the bodies as quickly as possible.
Thank you. I did know about language review. I just wanted to make sure that the vote is trusting that the discussion that we've had based on this is what we actually pass out of committee. So just making sure. So I'd like to move ought to pass as amended based on the proposed amendments provided by the sponsor on the white sheet.
Thank you very much.
One of the white sheets.
The white sheet that begins with the word recommendation. Okay,
So ought to pass as amended.
thank you. Is there a second? Seconded by Representative Kuhn. A discussion committee members? Representative Sinclair.
This isn't particularly in furtherance of discussion. I'm just hopeful that we might take perhaps a 4 or 5 minute caucus before voting.
Okay, thank you. And we can caucus right now if committee members wish, or we can have a discussion of Eli.
I'm going to re-highlight, and I apologize for not highlighting it before. There was an ask of the judicial branch for an extended implementation date just so that they can get their ducks in a row to make it work. And I'm hearing that I think it is April 1st of 2027 would be the ask for an effective date of these changes.
And so for the person who made the motion, Senator Talbot Ross, is that acceptable to you?
Yes, thank you, Madam
And
Chair.
Of course, there is a member or the representative. There is a representative of the judicial branch if the committee has questions as to why they ask.
It does seem to be quite a long time. I mean, I was hoping that we could affect this change a whole lot I mean, I just think of all the people that this will impact for a year and a half. Yeah, but perhaps we can hear a little bit, Madam Chair, if you don't
Thank
mind the
you.
indulgence.
Yes. Welcome.
Yes, Julie Finn from the Maine Judicial Branch, and the more time is really for programming because all of the surcharges are programmed into our system. And our tech staff is really maxed out at the moment and until the beginning of 2027 with the enterprise justice rollout, which is happening region by region. And so the date gets us past that when they will have time freed up. That is the reason for the extension.
Would you have to program two different computer systems if you were trying to
No.
bring it online? No.
At that point in time, it would just be the one. So that.
But if you brought it online 90 days after adjournment, would you have to program two different computer systems?
I believe we would, and for a very short period of time. And with only programming the one, also, we would not need to have any sort of fiscal note. All we need is more time.
Senator Talbot Ross.
Thank you so much. Just two questions if I could. So if you were to do it dual, I mean, if you were to 90 days after and then change, that would carry a fiscal note.
Hard to say. I haven't checked with my people specifically because they just requested that the amount of time be extended to get us past enterprise justice. I think they were assuming they would not be dealing with me just at this point.
So that could influence our decisions here, quite frankly. And maybe toward that end, is it plausible to say no later than April 1st, 2027, so that
Yes,
if it is plausible to do
absolutely.
now and then update without a fiscal note, then we've got our bases covered?
Absolutely.
Okay, that would be the up to April 1st, 2027. So there's at least a deadline, but if we're able to do it before then we've given you permission to do so. Thank you, Madam Chair.
Thank you. Representative Sinclair and then Representative Crusoe.
Good afternoon, Julie. From the branch's perspective, is there any reason to think that the sentencing judge or justice would not get the question right if we did leave in the waiver possibility as initially proposed in the bill before us?
Get the question right? I'm sorry.
The question as to allow any complete or partial waiver of the additional assessments that are proposed by the bill.
I'm sorry if I'm being obtuse. I'm not sure what you're asking. I don't understand.
So the bill initially had in it the ability of the sentencing judge or justice to essentially suspend or dispense with some or all of the additional assessment if the circumstances of that particular case so warranted in the interests of justice. Does the branch believe that there is a reason why we ought remove that? As is proposed in the most recent amendment.
We did not comment in that regard on this bill, so that we took no position on whether that was there or not. And I believe, as Ms. Melnick indicated, Clack had mentioned that it was inconsistent with other provisions of law, but the judicial branch had no position on that.
Representative Crusoe.
I don't know if this is a question for Julie or a question for us. I'm just struggling with waiting a whole year for this when it seems it's not a heavy lift. It's just changing some dollar figures and bringing parity to what we would like to do more for the victims and this crime. So I'm just struggling with why it takes a year. I don't see it.
I mean, Representative, it really is just mostly dealing with two systems rather than one. Dealing with two is just a transitional thing, and it's difficult. There's no question about that. But if we wait, we can just deal with the one system. I can certainly, as Senator Talbot Ross mentioned, we can try to move it up. They have, our tech people have a process and a list of tasks, and it'll get on the list. They are just really straight out doing other things right now. And that's the only reason, that's the only reason for the delay. I don't know programming, so I
Yeah.
can't tell you how complicated it is.
Any other questions for Julie Finn? Seeing none, thank you.
Thank you.
So we have a motion by Senator Talbot Ross and a second by Representative Kuhn. Additional discussion? Oh, let's take a caucus break. It's 3:15. Let's come back in 5 or 10 minutes, please. Committee members, could we please return to the horseshoe? We are in the home stretch. We're still on our work session on LD 2168. We have a motion that's been seconded. We've had committee discussion, questions. Is there any other questions, discussion? Eli, do you have anything you want to share with us?
While it was discussed after the motion was made, I'm not sure that, or I'm not sure if that additional time language is to be included in the motion.
Thank you for that question. Senator Talbot.
Thank you, Madam Chair. I think is Julie still here? Yeah, okay. My notes, what I think we had said, no later than April 1st, 2027 for an effective date. And what we'd like to hear back, what we still need is to understand if there's going to be any fiscal note applied by putting it into the dual systems, I think. But the motion just includes the language no later than effective date no later than April 1st, 2027, unless Julie has some more information for us.
Yeah.
I did not. I just want to make sure that's the right language. No later than. And that would you be able to let us, okay, let's leave it at that for the moment.
Okay, thank you. So we have a motion, it's been seconded and clarified. And is there any more discussion before we move on to a vote, committee members? Seeing none, Clerk Cadet, would you please call the vote? Yes. Oh, I'm sorry. I did not see your hand. Representative Sinclair, please go ahead.
Madam Chair, I didn't take it as a slight at all, and I appreciate Representative Henderson's having pointed out that I stuck my hand up. I would have felt a lot better about this bill. I would feel a lot better about this bill if the sponsor and any interested advocates had done a bit more to reach out to the different stakeholders who had expressed opposition to the bill. I'm thinking in particular about Maine Women's Lobby and Swirl. Yes, it's important to talk to advocates. It's also really important, from my view, to talk to those who actually live and work in the space. And then to a much lesser extent, the concerns that Clack brought up in opposition. So I won't be supporting the motion on.
Thank you for that statement, Representative. Anybody else like to be recognized before we move on to a vote? Representative O'Halloran?
Yes, just for clarification, this is just children and people with mental disability, not adults that are consenting or not consenting or anything, correct? Thank you.
Yes. Anything else, committee members? I think we're ready for the vote.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Representative Kuhn.
Yes.
Representative Kuhn votes yes. Senator Hagan. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Sinclair.
No.
Representative Sinclair votes no. Representative Pugh.
Yes.
Representative Pugh votes yes. Representative Henderson.
Yes.
Representative Henderson votes yes. Representative O'Halloran.
Yes.
Representative O'Halloran votes yes. Senator Talbot Ross.
Yes.
Senator Talbot Ross votes yes. Representative Lee.
Yes.
Representative Lee votes yes. Representative Sato.
Yes.
Representative Sato votes yes. Representative Babin.
Yes.
Representative Babin votes yes. Representative Caruso.
Yes.
Representative Caruso votes yes. Representative Dana. I'll recall the absentees. Senator Hagan. Senator Hagan is absent. Representative Dana. Representative Dana is absent. Madam Chair. I have 11 members voting in the affirmative, 1 member voting in the negative, 2 members are absent, and that is the vote of the committee.
Thank you very much. And Representative Sinclair, what is your report?
Not to pass.
Okay, thank you very much. Eli, do you need anything else from us at this time?
Nope.
So with thanks to the bill sponsor and all those who participated, We're closing the work session on LD 2168. Thank you, everyone. I believe committee members that we may have some right to know. Do we have other work? No, okay. I saw Janet and I was struggling to see what treats she had in mind for us, but. Okay, so it appears that we are done our work for the day. Is there a motion to adjourn? Oh, Representative Babin, is there a second? Lots of seconds. All those in favor? Thank you for all your hard work today, everybody.